Good afternoon, sir. Can you see and hear me?
Thank you very much, yes.
Thank you. Mr. Clarke, we're going to move now to January 2014. Just to recap as to where we are, by the beginning of 2014, you've had that conversation with Gareth Jenkins, you've written the advice on the issue of his evidence, that it had been, I think the word was, fatally undermined. You had the second sight report, you had the Helen Rose report, the shredding advice, and the issue that you were just addressing before lunch was a historically inadequate prosecution policy.
Yes.
That wasn't really even a policy in itself.
Yes.
Can we please look at poll 001082223? This is a case review that you carried out in respect of Misra. The date of this review is the 22nd of January 2014. If we scroll down, we can see, well known to this inquiry, the offence for which she was sentenced to a term of imprisonment, 15 months imprisonment. If we scroll down, please, you assess, you have a look at the case history, various timelines. You look at the defence statement to paragraph 7, and I'd like to look at paragraph 8 to begin with. At paragraph 8, you say there was a first defence statement, and then Mrs. Misra changed her solicitors, and a second defence statement was served rather late in the day, either just prior to or perhaps on the first day of the first trial listing. And you say, Mrs. Misra partially resiled from the allegation that staff members were stealing from the office and instead asserted that her training was deficient. Again, allegation was made that the Horizon system was at fault for the now unexplained losses. And paragraph 9, you record certain details from the defence statement, including at subparagraph 2, she telephoned the helpline repeatedly, and despite those calls, the losses increased over the page. Training was mentioned, but seemingly not criticised. And then at paragraph 10, you say, on the first day of her trial, listed in June 2009, Mrs. Misra raised issues of Horizon fallibility for the first time. She explained in the October trial that she had learned about Horizon failings from an article in Computer Weekly magazine. She read this on the day before her first trial and realised the doubling up errors described there had happened to her, and that's why the judge postponed that trial. You then go through the evidence that was adduced at trial, and if we could keep on scrolling down, please, over to page 8, and the summary of the evidence of Gareth Jenkins. So the evidence of Gareth Jenkins is set out from paragraph 20 onwards. Paragraph 23 says there is no evidence to support any of this hypothesis that had been put forward. There is no evidence to suggest that the system is corrupt. And then you address the calendar square issue. Now, by this stage, January 2014, what did you know about the calendar square bug?
I think I knew that it was a Horizon legacy bug and that it produced false balances, and I think that was the extent of it. I never claimed to be an expert on what these bugs did or didn't do.
No, but you knew about the two in Horizon Online and
Yep.
the issues of reliability with Mr. Jenkins, and we now have here a third bug, one that is in fact affecting legacy Horizon. Yes. Did that not cause you to rethink that 2010 start date for the SIFT review?
I think I raised that with Brian Altman after I did this advice in one of our conferences, but that was pretty much the first inkling that I had that we ought to have gone back further.
And what was Mr. Altman's response?
I think he was receptive to the suggestion, but I don't think we did enough to make it happen at that stage. It happened later on, but I accept it should have happened earlier.
It says there, about halfway down 24, Mr. Jenkins researched the calendar square problem, and whilst he did not examine the data logs, determined the problem was fixed. Over the page to paragraph 26, about halfway through that paragraph, it says the calendar square issue, as it may have affected West Byfleet, was then dealt with in some considerable detail. Importantly, Mr. Jenkins said he had identified 2 isolated events similar to the root cause of the calendar square problem, but not in the tens of thousands of events as had manifested at Calendar Square. So it seems as though there were some events, some issues, albeit not as serious as Calendar Square. 27, in his analysis of just under 500,000 transactions from West Byfleet, Mr. Jenkins had found no evidence of any computer malfunction other than the already mentioned Calendar Square problem. And then 29, you say as follows: it becomes apparent in cross-examination of Mr. Jenkins that whilst he had disclosed material to Professor McLachlan, he had done so in a piecemeal basis, only when asked to do so, and very late. Now, isn't that exactly what was happening to you back in June 2013, late disclosure of information that you weren't aware of?
No, non-disclosure in 2013.
Is it consistent with the view that you had taken back in 2013 that he was an unreliable witness?
Well, there's a sort of timeline to this. That I've seen and heard reference to a document on the Misra Seema case produced in December, a very short document, which has been erroneously attributed to Harry Bowyer. What in fact happened was that I can't remember whether I asked to review the Seema Misra case or they asked me to review it, but it came up for renew. And in December 2013, I did a very short form initial review, and I think that's the document that was attributed to Harry Bowyer because I didn't sign it.
Yes.
And that review advised disclosure of the material we were...
Absolutely, and that's a document I'll take you to in a moment.
Okay. That document was written off the back of, and this is going to take me on to another concern that I've had since then. That document was written off the back of a transcript only of the judges summing up in the Seema Misra trial. I'd asked for the entire file. I was told it wasn't available. I wasn't told why it wasn't available, but I was told they had a transcript of the summing up. Frankly, it never occurred to me to ask why have you only got a transcript of the summing up, but there we are. So the December document I wrote off the back of the judges summing up, and the judges summing up, the way in which that was crafted suggested that disclosure ought to be made.
It was very clear in that December advice that your view, or Cartwright-King's view as it was put, was that disclosure should be made to Mrs. Misra.
Yeah, well, Martin Smith was right to the extent that I always sign my own documents. That was signed Cartwright-King because I suspect sometimes I would write the bare bones of something and then give it to Harry Bowyer or Martin Smith and say, right, that's essentially what I want to say, finish it off and send it out. And I suspect that's how it came to be sent out under the Cartwright-King banner rather than under my name. But if you look at the document, it's clearly my writing style, my narrative, it's my document. What then happened was I was delivered the transcripts of the evidence of the trial in January 2014, and this document effectively it was written off the back of those transcripts. Again, no file, no prosecution papers, no witness statements, nothing, just those documents. And I wrote this off the back of the transcripts of the entire trial, and what I'm doing is recalling the evidence here as it appeared in the transcripts, and I came to a different conclusion. Which is why disclosure wasn't directed at that time. So that's the timeline between, and then there was I think there was a third look at the Seema Misra case later on in the year by Brian Altman, and Brian Altman said in terms, you're wrong, you should order disclosure in this case, and so we did. That's the timeline of what happened. But I don't want people to think that Harry Bowyer produced a document I produced.
That's quite a long answer to quite a simple question,
sorry, yes.
Which is paragraph 29. Wasn't it clear to you by that stage, you had formed the view that Gareth Jenkins' evidence had been fatally undermined and he was an unreliable witness.
Yes, that was
combined with paragraph 29, that what in fact happened in that Misra case, you had formed the view that he disclosed material on a piecemeal basis only when asked to do so and very late.
Yeah.
Do you not look at that trial at that point in time, knowing the conversation you had personally had with Gareth Jenkins and knowing all of the various points that I've taken you to a number of times that happened after that, and think we need to be disclosing material to Misra?
I've looked at that paragraph several times since and questioned myself as to why I wrote it and didn't ask for disclosure. The only, and it's not a justification, but maybe it's an explanation, the only explanation I can come up with is that I can imagine myself looking at the transcripts of the trial, which went back to 2010, and asking myself the question, what was the position in 2010? At that point, according to the timeline, if you like, Gareth Jenkins was not a tainted witness, and he had given evidence, and according to the transcripts, there had been 3 separate attempts at litigating in front of the judge the disclosure issue, and the Falkirk bug had been litigated, and the judge had on 3 occasions ruled no disclosure. Now, I accept that that was looking at things the wrong way now, but I think that must have been my thought process then. Now, I can't reconcile this document with what should have happened. I accept that. So the short answer to your question is yes, you're right.
Could we please turn to page 15? Paragraph 57, you're setting out here various conclusions. In coming to my conclusion on this aspect of the disclosure process, I have considered Mrs. Misra's failure to raise Horizon as a defence until so late in the day, her inability or unwillingness to offer anything more than a generalised and incoherent indictment of Horizon, the approach taken by Professor McLachlan, and the duties relating to disclosure placed upon the shoulders of any prosecutor. Just pausing there, the failures of her to raise Horizon as a defence, inability to offer anything more than a generalised indictment of Horizon. I mean, you were in the same position, weren't you, back then, that you weren't aware of how legacy Horizon could cause issues
Yes.
balancing. So do you think that's an unfair statement?
Yes.
At the bottom of the page, paragraph 58, the final sentence on that page says, accordingly, I conclude that no meaningful criticism can be made of the disclosure process taken by Royal Mail Group during the pre-trial and ongoing disclosure phases of this prosecution. Am I to understand that on reflection you disagree with that?
Yes, at the time I was over-influenced by the views of the trial judge. That was an error, and I agree with your characterisation that that is a wrong view.
Thank you. Can we please turn to page 19? Paragraph 68 onwards. 68. Having considered both Mrs. Misra's case and the details of the Second Sight interim report, I can divine no instance where there is any convergence of similarity of complaint on the issue of Horizon fallibility. It is not the function of the prosecution to respond to general and unspecified allegations and requests for disclosure in the hope that material may turn up to make them good. And in this case, I conclude that there is precisely the test to be applied, this is precisely the test to be applied on issues of post-trial disclosure. I'm also of the view that the Second Sight interim report does not and cannot cast doubt on the safety of the conviction, not least because the vast majority of matters dealt with in the report post-date this trial by several years, and those that fit the chronology of this case bear little or no factual resemblance to Mrs. Misra's circumstances. In any event, the report is now in the public domain and most likely in the hands of Mrs. Misra. Pausing there, reflecting on that, do you agree that the advice there or your conclusion there is problematic?
Yep, it's not problematic, it's wrong. The first part of the paragraph is a paraphrasing of the decision in Re H and Re C. The second part is wrong.
Paragraph 69. As for the Helen Rose report, that matter goes solely to Gareth Jenkins' knowledge of Horizon concerns arising some 5 years after the events considered in Mrs. Misra's trial, and his credibility as an expert witness in 2013, an analysis of the events dealt with in that report, and the potential that Gareth Jenkins' credibility as a witness might be undermined in 2013 does not, in my view, lead to the conclusion that the material which might undermine his credibility now ought to be made available so as to do so in relation to a trial which occurred in October of 2010. Again, disagree with that now.
Yeah, it's wrong.
Conclusion. I advise that neither the Second Sight interim report nor the Helen Rose report meet the test for disclosure in this case, and neither report should be disclosed to Mrs. Misra's representatives. The focus in this and in all of, I think, the other similar cases that you looked at was on the disclosure of the Second Sight report and the Helen Rose report. Do you think that was also an error because there was more information that you were aware of that related to, for example, putting the jigsaw together regarding the unreliability of Gareth Jenkins?
Well, I think that you say there was more information. To my mind, there were 3 strands of information. There was the Second Sight report, the Helen Rose report, and the third strand was my conclusion that Gareth Jenkins was a wholly unreliable witness. I accept that now that was wholly disclosable from day one.
I think I can probably take you through the rest quite quickly in that case. Can we have a quick look at poll 000668850?
Before that comes on the screen, can I just confirm that I've understood you correctly? In both your appraisals of the Seema Misra case, the information that you were acting on in the sense of the paper before you was simply various transcripts. In December, a transcript of the summing up. In January, a transcript of the evidence given. At no stage did you see the prosecution file, is that correct?
That is correct. I had asked for it on a number of occasions. I learned from this process that somewhere there is a digital file. I came to the conclusion during the course of this process that it was deliberately withheld from me. I could not understand why Post Office had a transcript of the summing up and later were able to produce a transcript of the trial proceedings, but according to them, did not have their own file, their own prosecution file and papers. But I never saw it.
And is it your view, let me ask you the direct question, that the file, whether in electronic or paper form, was deliberately withheld from you?
That is now my view.
And is that now your view in the sense of a view you've come to, having no doubt listened to parts of the inquiry and looked at various documents, or was that a view which you formed earlier than that?
I think it crystallised. I'll be frank, I watched Roderick Williams, I watched Jarnail Singh twice, I watched Martin Smith, and I watched Harry Bowyer. And as a result of that, combined with the documents that I've seen in this process, that crystallises my view that I was misled and deceived.
Thank you. Right.
Forgive me, in particular, in reference to the site of the Seema Misra file.
Yeah, that's what we were talking about. That's what I understood you to mean.
But also in general.
So, all right. So that I'm clear about what you're saying, you are asserting that you were misled deliberately in the Seema Misra case.
That's my belief, yes.
By the withholding of the file, in effect.
That is my belief, yes.
But you also say that you have a belief that you were misled on a wider basis.
Yes, Post Office repeated their protestations that since day dot there was nothing wrong with Horizon, when they clearly knew that there were issues with Horizon.
All right, thank you. Sorry, Mr. Blake.
Not at all. And just following on from that, can you assist us with who it was that you were communicating with at the Post Office in respect of the Seema Misra file?
Jarnail Singh, Roderick Williams. At arm's length, first of all, Susan Crichton and Christopher Oyard. I think that's probably about it. We had meetings occasionally. I had no direct, I think I had a meeting with Christopher Oyard, and I had one, maybe two meetings with Susan Crichton. By and large, everything I got came through John Elsing and Roderick Williams, but you could see from the emails that those two individuals were very regularly copied in to this correspondence, so that's why I include them as well.
Thank you. We see from the document that is currently on screen that you completed the Misra full review on the 22nd of January 2014. Is that correct? Or thereabouts?
That's what it says, yeah.
Can we please go to poll 000666853? This is an email that you will have seen in your preparation.
Yeah.
That says at the bottom email from yourself says few. Now, the suggestion might be that was few, we don't need to disclose anything to Seema Misra.
Yeah, that's not what it meant. I had just conducted a review of the case from probably 8 or 9 inches of transcript of evidence. The few was in reference to that task.
Thank you. If we could please turn to the December document, that's poll 0019859. This is the December advice I think that you were talking about, where at page 11 it addresses Seema Misra's case. The bottom of the page, and scrolling down, and a very clear picture is painted there that there should be disclosure to Seema Misra. And that is the 5th of December 2013. You've explained your reasons for having formed that view, but is it now, on reflection, your view that actually, in effect, your gut instinct was the right one?
Yes, clearly.
I'm going to look at one other case review. It's earlier in time. It's poll 000060715. We're going back to the 19th of July 2013, and this is the case of Hutchings. If we could look at page 2, please. At the bottom of page 2, you set out Mrs. Hutchings' defence at trial. In her interview, prepared statement and interview. She says that she migrated to Horizon Online in 2010. Ever since we have been with Horizon Online, the balances have been wrong. At no stage have we stolen money, nor are we aware of making mistakes in our day-to-day operations. Because of this, we've always believed that the incorrect balances would be sorted out through transaction corrections. She then, over the page, please, sets out various other issues, difficulty with the helpline, and various other hardware as well. Page 5, please, is your conclusion. And that is, if we scroll up, to paragraph 15, you say, given the chronology and circumstances of the guilty plea and the reference in the basis of plea to the leading case on the topic of the charging of false accounting, the Second Sight interim report and the Helen Rose report would not have been disclosable during the currency of the prosecution and accordingly do not now fall to be disclosed. Is that a conclusion that you stand by?
No.
Why not?
On the face of it, if you look at the case of Eden, which is the case that's being referred to here, and I paraphrase, the Court of Appeal talks about it being culpable, if you like, to, let's rewind slightly. People will false account in order to hide unexplained losses. The case of Eden deals with that proposition by indicating that people who have done that will be guilty of the offence regardless, even if the falsification is simply to put off the fateful day when they have to account for their actions. I think I was overly influenced by what the Court of Appeal said in that case without paying enough attention to the reasons behind the pleas themselves. And the reasons behind the pleas themselves were patent. Miss Hutchins didn't know why the errors were occurring, but was seeking to, as it describes in Eden, put off the fateful day.
Looking back at these two examples, are they indicative of, on reflection, a overly narrow approach to disclosure to people who had been convicted of criminal?
Yes, I think I suggested this morning that we probably got a bit case-hardened, a bit cynical, and we shouldn't have done. And I think these are good examples of that. Well, for my part, I don't speak for my colleagues.
I'm going to turn now to the topic of mediation and the mediating of cases where convictions had occurred. Can we please turn to poll 001-25222? This is an advice of the 9th of July 2014. So we're moving on now to the summer of 2014. You're asked to advise on the differentiation between a caution, guilty plea and full trial verdict, appeal rights exhausted, and whether there is an impact on the risk level to the Post Office. Can you assist us with why this advice was produced?
I think that Post Office wanted some help with the way in which the process approaches these individual issues. I think there was a deficit of knowledge in criminal procedure in Post Office and in the mediation scheme, and they wanted to understand how things worked.
If we could turn to page 5, please. Paragraph 17. I'm just going to read those final paragraphs, 17 onwards. You say, given that no applicant has thus far sought to obtain permission to appeal from the Court of Appeal, it may properly be inferred that none will do so, save in the event that some new circumstances arise which alters the position. The request by some applicants that the Post Office assist in this process is an example where, if the Post Office were to accede to such a request, such a change could result in an appeal. Of more concern in the context of appeals launched off the back of the mediation scheme is the potential for inadvertently placing a different gloss or interpretation on facts or otherwise saying anything which may be said to be inconsistent with the way in which the case was originally prosecuted. There, the risk to the Post Office is substantial. A concession, for instance, that a horizon shortage was or may have been the result of human error could fatally undermine the original basis for the prosecution and conviction. Such a concession may well lead to an appeal. Thus, in the context of the risk of mediating a case, if the sub-postmaster has a caution or conviction, the risk is twofold. First, whilst no sub-postmaster or clerk convicted of an offence prosecuted by the Post Office has sought to lodge an appeal, mediating the case has, off the back of the scheme, already appealed and lost. A sub-postmaster may receive material on which he might base a further appeal. Two, an applicant sub-postmaster who has not sought to appeal against his conviction may nevertheless do so in circumstances where he received material upon which he could found proper grounds of appeal. We judge the risk to the Post Office of the former as being minimal if non-existent, we judge the risk to the Post Office of the latter occurring as being substantial and only mitigated by very careful consideration of the Post Office mediation responses prior to publication to the working group or the applicant. Reflecting on what is said there, and we'll come to look at more of your advice in respect of the mediation scheme, do you think that it was right to caution against mediation that would provide people with material upon which they could found proper grounds of appeal?
I was fundamentally opposed to the proposition that those who had been convicted of criminal offences ought to be allowed into the mediation scheme. My view has always been and remains, I cannot understand how you can mediate with somebody whom you have caused to be convicted and sentenced for a criminal offence. To do so would undermine the very proposition that you had properly prosecuted and caused them to be convicted in the first place. The proper place for a complaint against the conviction and sentence was the Court of Appeal. And I very strongly felt that by allowing people who had been convicted into the mediation scheme was trespassing upon the territory that was properly the Court of Appeals.
The way that it's phrased, though, in this advice and future advices relates to giving potential appellants the material upon which they can found their appeal. How is that improper?
Because the disclosure process that we were operating was intended to deal with that problem.
The concern that you've raised here, though, is wider than just disclosure of, say, the Gareth Jenkins, the Second Sight report or the Helen Rose report, which is what your review was looking at. It's simply a concession that, for example, a shortage may have been the result of human error. So it's small pieces of information is your concern going to potential appellants to on which they can found proper grounds of appeal.
I think it goes beyond that. The very proposition that you are mediating with a convicted postmaster can be taken to the Court of Appeal as a ground of appeal was the concern I had.
And looking back at it now, do you still hold that view, or do you think that that was unduly restrictive?
Two answers. My view now about trespassing on the territory of the Court of Appeal remains. I'm a bit straight line like that, as I think I suggested earlier. But I agree that what I've formulated here is too restrictive. But it all encapsulates the very basis of my opposition to mediating with those who have been convicted in the first place. I just thought it was, well, there were two things I thought. The first was I thought it was the wrong way round. And the second, and this is why I was opposed to the mediation scheme in general as far as those were convicted, is because I saw it as a way of Post Office keeping them quiet. And I thought that was improper as well.
Can we please turn to WBON 0000870? I'm taking you to this version just because there was a redaction to, for the purpose of the transcript, poll 001487110, although I believe that redaction may now be lifted. And it's the bottom of the page. Sorry, could we go to the bottom of page? Yes, if we could scroll down slightly, thank you. There's an email from Martin Smith to Andrew Parsons. Please find attached the advice of Simon Clarke, which contains speaking notes as requested. Can you recall what the purpose of the speaking notes was?
I think it was set out in the earlier email, wasn't it? Because there was going to be a meeting of the working group and somebody wanted a shorthand way of describing what I was saying in my advice. I'm slightly speculating, but I think that's what the idea of the speaking note. So I did the advice in full, and then I think at the end I gave some bullet points as to how to encapsulate these in short form.
If we scroll up, please, we then have an email from Andrew Parsons to Mr. Smith. And he says as follows. He says, at the working group meeting last Thursday, the Post Office floated the idea of not mediating criminal cases, as per your advice, and received fierce pushback from the Justice for Sub-Postmasters Alliance and some resistance from Tony Hooper. For various reasons, we never directly addressed the question of mediating and those two named cases. Those questions are likely to be raised on the weekly working group call on Thursday. The Post Office would prefer to avoid leaving the working group with a yes-no decision on whether to mediate a criminal case or not. And he says further down, he says, please bear in mind that the Post Office are going to get pushed hard on this topic by the Justice for Sub-Postmasters Alliance and Tony Hooper, so your advice needs to be very robust. We may need to set up a meeting or call with you and the Post Office so they can test your thinking. So you were aware at this stage that Sir Anthony Hooper, former Court of Appeal judge, was strongly in favour of mediating cases?
I don't know about strongly in favour. I knew he was in favour of it, yes.
We see then another advice, a second advice, the 15th of July. That's poll 00148-720. What was the purpose of this second advice? Was this to set out in more detail the information you had already set out?
I think so, yes.
And there's a section, if we scroll down, criminal offenders and mediation. It's our considered view that no applicant guilty of a criminal offence committed against the Post Office should be allowed into the scheme, for to mediate such applications will be to leave the Post Office open to a number of alarming consequences. These consequences include, but are not limited to, the fact that entering the scheme indicates that the Post Office is at least prepared to concede that they may have erred. Similarly, that the fact that one such applicant has been allowed to enter in the scheme sets an unfortunate precedent. And then we have 3. It says as follows. I'm going to read to you the final sentence in 3. It says here, the risk to poll is substantial. A concession, for instance, that a horizon shortage was or may have been the result of human error would certainly undermine the original basis for a prosecution and conviction founded upon the reliability and integrity of horizon, perhaps fatally. That's an expansion of the point that we were previously looking at. And then if we scroll down to 4, you say the very process of mediating gives rise to the possibility that it may yield results. The risks are manifest. Number 1, any competent lawyer would advise that such an outcome represented a substantial concession by the Post Office to the effect that the conviction or caution was unsafe. Such advice would inevitably lead to an appeal. Number 2, the setting of a precedent. If we scroll down, 3, the message sent by the mediation of such applicants will, in our view, never be a positive one. Honest sub-postmasters, staff, agents and employees may feel undermined and devalued. And then you offer further potential and, in your view, likely side effects. And this is where we get to the issue of publicity. And you say as follows. You say, whilst the issue is strictly outside of our criminal purview, we feel bound to point out the potential for adverse publicity generated by the mediating of criminal applications, and particularly where some concession, agreement or payment is made by the Post Office, is inestimable. You refer there to the knock-on effect. You also at 3 speak to a considerable assessment and disclosure exercise that would be caused, and 4, claims for compensation for incarceration, loss of reputation, loss of income and assets, and for general loss. Looking back at those 4 topics, do you think that they were appropriately contained within your advice?
These represent my fundamental opposition to those convicted of criminal offences being entertained in the mediation scheme at all. But yes, I agree with the proposition you advance. They're not really proper considerations, are they?
Because if, for example, in respect of publicity, if somebody has properly been given information that allows them to appeal and others find out about it, there's no problem with that, is there?
No. I think my concern, my more valid concern, was the fundamental one that I've already expressed, which goes, if you mediate with somebody whom you've been involved in convicting and sentencing, you are immediately saying to them, we haven't done our job properly and you should go to the Court of Appeal. And my view has always been that is the venue for such a complaint.
That is a risk that is identified in this advice, but do you agree or accept that, in fact, if you look at this advice in the round, there are a number of other factors that you've highlighted and relied upon that are not proper?
Yeah, I think I went too far. Yes, I agree with that.
Could we please look at page 4? And you say you went too far. Why did you go so far?
That's difficult to assess this far down the line.
Was there a concern within your firm that, in fact, you had been involved in the prosecution of sub-postmasters?
No. I think it was more to do with the concern within Post Office that they were keen to avoid adverse publicity. And I suppose to a degree, therefore, we and I are pandering to that concern here.
There's then an alternative approach set out in paragraph 7, and it says it suggested that rather than mediate applications for criminal applicants, an alternative process be adopted. That proposed process consists of the holding of face-to-face meeting with the criminal applicant so as to permit the Post Office to both frame a different agenda and to explain Poll's findings rather than to settle a dispute in circumstances where it is made clear that no compromise is being offered. Those exact words are contained in the email from Mr. Parsons that I took you to before. Do you recall copying the alternative approach that was suggested by...
I don't recall it, but it seems likely.
And why is that? Were you here justifying a position that Bond Dickinson had taken?
Well, can you move it up a bit to see what I said? Because
yes, I mean, perhaps you can see it side by side with WBON.
No, forgive me. No.
Sorry.
This particular document, can I see paragraph 8, please?
Yes, absolutely.
Yeah.
So it's phrased in terms of we are of the view of X, Y, and Z, but in fact, it also seems to have been the view of Mr. Parsons prior to this being written. Are you in some way selling a combined approach that avoids mediation with those who had been convicted?
No, I'm setting out at paragraph 7 the proposal that appears in the Bond Dickinson email, and in paragraph 8 I'm saying it should not happen. I was and remain, I think horrified is the wrong word, but I did not like the proposition that went, we should have discussions of any sort with those who had been convicted by Post Office of criminal offences, because A, it gave those persons false hope as to what may or may not be the outcome of those discussions, but B, it goes back to my central thesis. The complaints were the purview of the Court of Appeal. And for Post Office to pretend to discuss potential remedies for people who had been convicted without those remedies coming from the Court of Appeal was frankly dishonest. I felt and feel that this was an attempt by Post Office to keep people quiet.
Thank you. I'm going to take you to a couple of emails of the 8th of October of 2014. Can we start with poll 0034931, please? The bottom email And you say to Jarnail Singh, I suggest that strenuous efforts are made to dissuade Sir Anthony Hooper from exercising his casting vote in favour of permitting any criminal applicant into the mediation scheme, particularly where the issue is whether the Post Office would agree to support an application for permission to appeal that conviction. If not, many of the remaining 37 criminal applicants will seek a similar concession, no doubt spurred on by Second Sight. If an appeal succeeds, Horizon's reputation would be fatally damaged, a further disclosure exercise would be required, and further appeals would be launched, including some of those 300 plus criminal convictions that we have reviewed. Whilst the Post Office could refuse to mediate this issue, the publicity generated by Second Sight would be unfortunate. Do you think that those concerns were appropriate?
This is me again saying to Post Office, you should not include convicted postmasters in the mediation scheme.
But taking, for example, number 2, Horizon's reputation being damaged, further disclosure exercise, further appeals, they in themselves would not have been a bad thing, would they, if they were based on...
Sorry, I'm talking over you.
Yes. If they were based on new disclosures being made, that wouldn't be a bad thing.
No, it's item number 2 is a statement of fact. If you went down this path, this is likely what would happen.
But it's part of your reasoning why strenuous efforts should be made to dissuade Sir Anthony Hooper.
It's part of my efforts to stop them from doing that which I thought they ought not to do.
And do you think, looking back at number 2, those were appropriate considerations to have had? No. We then see at poll 0034938, I think Mr. Singh has asked you to email again on, if we scroll down, we can see the same issue, same day. Do you recall, it's a later email, I think, despite the timestamp here showing 12:34, it is in fact a later email to the one we've just been seeing. Might you have been asked to send one that could be forwarded on, for example?
It's likely.
We see there are very similar points being made.
Yeah.
If we scroll down, please. If we have a look at, for example, 2 subparagraph 4, it says, the Court of Appeal sits in open hearing and the press are permitted to attend and report upon proceedings. Given media interest thus far, it is inevitable that a largely hostile press would attend and report widely on the proceedings. Do you think that that was an appropriate consideration?
It's a statement of fact as to what would happen. It's not a proper consideration, but it's a statement of fact as to what I thought would happen.
Is it proper for you to have advised the Post Office that an implication of conducting mediation with those who are convicted is that there could be effectively bad press?
Yes, because I'm seeking to dissuade them from following that path. And this is one of the tools with which I sought to dissuade them. I accept it's not a proper consideration in the decision as to whether or not to mediate. My concern was that those convicted of criminal offences ought not to be in the mediation scheme at all. This is a further effort on my part to prevent that happening. And in that context, I thought it was an appropriate tool. This is what will happen if you don't follow my advice.
We do see, and we've seen from some very early documents that I've taken you to today, the repetition of concerns about the press, concerns about publicity. We have that public interest immunity hearing, avoiding press reporting on issues that were then arising. Do you think that you were unduly or overly concerned about press intrusion?
I think the PII hearing goes into a separate category, but putting that to one side, all of the rest of it was made very clear to us by Post Office that that was a major concern of theirs, and I've used the word pandering, and I don't resolve from that.
and who at the post office was concerned
Oh,
about.
the people I dealt with, Roderick Williams, John L. Singh.
Could we please turn to poll 00150,390? And this is a draft letter to Sir Anthony Hooper, 19th of December, 2014. You say we are asked to suggest the text of a letter to Sir Anthony Hooper. Halfway down two, please. You say halfway down, there's just a sentence there that I'd like a little bit of clarity on. You say, for Sir Anthony to suggest that because an offence of false accounting could have been founded upon a pre-existing but unidentified horizon fault, such that culpability of the offender is reduced because there may not be real loss, takes matters no further and indeed misses the point. Can you assist us with what you meant there?
It's parroting, or paraphrasing what was said in Eden, isn't it?
Can you expand on that slightly?
I get back to the authority of Eden, about false accounting to hide unexplained loss, thereby putting off the fateful day, is still false accounting. It's essentially what Eden says, and I'm paraphrasing that here.
If we scroll down, it's paragraph 4 where we have the proposed wording. I'm just going to take you to a few paragraphs from this. The second paragraph down ends as follows. It says, I would point out that in every case the available evidence has been considered and nothing has been identified which could be said to render the conviction unsafe. We are concerned that by permitting the hearing of one convicted applicant's case, we may be setting a precedent which others would wish to follow where necessarily they could not. This is particularly true of those charged with fraud as opposed to false accounting. In many cases, the facts were similar. Cash was being declared as being on the premises when it was not. We are further troubled by the possible implications which may arise once an applicant has had his or her hearing. We consider that there emerges a clear potential for the launching of appeal proceedings in circumstances where there should be none. The suggestion that the identification of some fault or root cause in the horizon system in order to determine liability for an underlying loss might permit a mediated settlement with those convicted of false accounting outside of or exclusive from the criminal legal process is, in our view, plainly misconceived. Over the page, please, to the penultimate paragraphs on page 3. You then point to substantial constraints, that's halfway down this paragraph, to the process, both by reason of the ages of some cases and the consequent limited availability of information and papers. Further complications arise because of a number of applications contain at best significant misrepresentations as to law and asserted fact, and in some cases manifest lies. Finally, on this point, the logistics and expenditure required to complete such an exercise would not be inconsiderable and clearly outweigh any possible benefit, which we do not in any event consider there to be. And finally, this paragraph, in terms of likely appeals arising out of the mediation settlement, we are of the firm view that such an exercise would be an exercise in futility. For as you're aware, the Court of Appeal are concerned only with whether, upon all the evidence presented, a conviction may be safe. Evidence of a guilty plea tendered by a defendant with the benefit of legal advice and in full knowledge of the consequences would be clear evidence of guilt, notwithstanding that there may have been an unidentified horizon fault. These are all very strong words proposed in a letter to a former Court of Appeal judge. Why did you consider your view to have been better than Sir Anthony Hooper's?
We're all lawyers. We're all entitled to take contrary views.
I'm going to read you the final paragraph on this page. You refer there to an alternative process. Yeah, and then if we scroll down at the very end, you say, or you propose saying, at the bottom of page 5, top of page 5, you're commending an alternative approach as the best method of achieving a just and equitable outcome for all concerned without engendering any false hope and the launching of misconceived appeals. Are you aware that the Post Office considered this to be too strongly worded?
I didn't know that.
Could we please look at poll 00150493, the bottom of page 1. This is an internal Post Office email, and it says as follows. Earlier in the week, Chris asked me to draft him a letter to Tony Hooper fulfilling the request to look again at Post Office's approach to mediating criminal cases. We had a draft from Cartwright King that contained some helpful material, but tone was not ideal. I mean, it doesn't say that it was too strongly worded, I suppose, but were you aware that the Post Office took a different view to you on the concerns raised in your letter?
I am now, because I was taken to this during the disclosure process of these proceedings, but I certainly hadn't seen that before. Forgive me, the short answer to your question is no, I had no idea.
And I think it's fair to say from your evidence today, you very much stand by your view on mediation.
I do, yes.
I'm going to take you to two very brief topics before I finish, and then we will take a break before questions from core participants. The first is stopping prosecutions. Can we please turn to poll 00114253? This is advice from you of the 12th of September 2013, and it starts, we've been provided with a copy of Bond Dickinson's helpful note entitled Civil Claims by Sub-Postmasters, and you're commenting on that note. Do you recall what that note was about?
Not at this stage, but this will help.
If we scroll down, cases terminated, you say as follows. To clarify, whilst a number of criminal prosecutions against sub-postmasters and clerks have been terminated since the publication of the Second Sight interim report, none was stopped because of errors found in the Horizon system. In all cases, the prosecution was stopped because it was considered that the continued prosecution of a particular sub-postmaster or clerk no longer remained in the public interest. Do you think that is accurate?
Yes.
Do you think it was also because of an evidential issue with regards to being able to prove the reliability of the Horizon system?
By and large, that is the reason why the prosecutions were stopped. That's different from being stopped because of errors. It's because Post Office were not able to demonstrate the integrity of the system because they didn't have an expert witness who was able to do so. And therefore, we took the view it was not in the public interest to continue those prosecutions.
But is that a public interest issue or is that a evidential issue?
I think it's both.
And do you think here and elsewhere it might have been sold internally as a public interest issue?
No, I'm not selling anything. My view was that this was a public interest issue. It is not in the public interest to prosecute people if you can't prove your systems were working properly.
But you say here, in all cases, the prosecution was stopped because it was considered that the continued prosecution no longer remained in the public interest. It seems you're ignoring there the fact that, in fact, you couldn't prove the reliability of the Horizon system.
No, you have to remember that the prosecutions that were stopped after a review. They were stayed, if you like. The investigations were pending. We devised a system called the stacked case system. And if I'm not mistaken, this is what we're referring to here. And the problem with the stacked case process was that they remained incomplete for a period of time. And there comes a time under the public interest test where too long has elapsed between the index offence, if you like, and whether or not it's appropriate to continue to prosecute. And I know that there were advices written, I think mainly by Harry Bowyer, but I may have written one or two, which in turn said, this case has been sitting around for too long because of our inability to find an expert witness, which I can deal with separately. I have some comments about that. But because of our inability, and because it's therefore been sitting around too long, it ought to be stopped, because it's not in the public interest to continue it.
Very briefly, because we are running
I
out of time, what was your view in terms of the failure to find an expert witness? You've said you had some views.
Well, I thought we were strung along for that. My very firm advice right at the beginning was you find an expert witness. Post Office said to me, identify candidates. I identified candidates. I recommended a particular organisation as being the most independent. I think it was Imperial College professors I recommended. I advanced that recommendation to Post Office. I repeatedly said to Roderick Williams, when are we going to hear, when are we going to hear? And it all came to naught. And I eventually heard on the grapevine that the reason it all came to naught was because it was too expensive.
Thank you. And very finally, theft and false accounting. I probably don't need to take you to the advice. I don't know if you're aware of Sir Anthony Hooper's evidence on that issue. Effectively, that your advice didn't reflect the real world. What do you say about that?
I think in terms of pure black letter law, I was correct. I think in terms of real world behaviour, he was correct. I think that people do see a plea of guilty to false accounting as being a plea of guilty to a lesser offence than one of theft. I accept that. My advice was directed, because sometimes I think that way, as a direct linear black line letter. They both carry 7 years. They're both offences of dishonesty. They're equal. But I think Sir Anthony Hooper was right on his real world take.
There are those who watch this inquiry who are interested in legal ethics.
Yes.
Looking back and reflecting on that, do you think it was part of your job to reflect also the real world as opposed to the black letter law?
Yeah, I think probably it was, yeah.
Thank you. So those are all of my questions. We do have quite a few questions from core participants, but perhaps this is the moment to take our mid-afternoon break.
Yeah. Well, let's devise a plan before we do, though. How many questioners are there?
Well, we have Miss Watt from the NFSP, who's going to be very short. We then have Miss Allen, who represents Susan Sinclair. Between them, they're going to effectively represent the Scottish side of things. We then have Mr. Henry, Mr. Steen, Mr. Maloney, who are all going to be relatively brief. And then we have Miss Oliver, who has slightly more.
Right. So what's the time now?
It's 3 o'clock, or almost 3 o'clock.
Right. Well, if we're only having one break, it better be 15 minutes, which gives us an hour and a quarter or thereabouts.
Yes. Alternatively, we can take 2 10-minute breaks if that would make things easier.
Could I just say, I don't mind running over if that's convenient for others rather than come back tomorrow.
I'm sure that that's right, Mr. Clarke, but I've already said that my concentration levels, starting at 9:45, start to wane, to put it mildly, once we're going significantly past 4 o'clock.
Okay.
And so, rather brutally, what I do is not make the witness come back, but make the advocates ask their questions in much shorter form. So I think what I'm going to say is that we'll start the process with those advocates who intend to be 5 minutes or less, keeping strictly to that. And then once they've finished, I will see how much time is left and divide it up accordingly. So we'll start again at 3:15, and then we'll take it like that, all right?
Thank you very much, sir. So we're going to first hear from Mr. Maloney.
Right.
Mr. Smith.
No, Mr.
Sorry,
Clarke.
Mr. Clarke, rather. That's a great start. The only matter I'm going to ask you about is the public interest immunity application on the 1st of July 2013. And the only document I'm going to ask you to look at is POL 20172804. First of all, in respect of this, you've said today that you spoke to Defence Counsel to give notice.
Yep.
Yeah. May I ask you what they said in response at all, if anything?
I don't recall, to be honest. Usually the response would be...
Well,
okay,
I'm just going to try and keep it tight here. So I mean no rudeness, Mr. Clarke, but there's lots of people to ask questions.
Okay.
But you don't recall. Do you recall what you said to them about what your application was in respect of, or anything?
I would have said I'm making a public inquiry interest application and an application to adjourn the trial.
Right, but no more details.
No more detail than that.
Thank you very much. Now, the material to be disclosed, you were always of the view that the information in the second site interim report, as you understood it, was disclosable in the case of Samra.
Yes.
Yeah. You said that the necessity not to infringe parliamentary privilege was the real basis for your application.
Yes.
And so, therefore, it was important to establish the origins and purpose of this report.
Yes.
Because if you weren't sure that there really were issues of parliamentary privilege, then it would have been wrong to make an application for public interest immunity.
Oh, I agree.
Yeah. And so, what steps did you take to confirm with Post Office that the report was a report where parliamentary privilege had any relevance or application?
That's where that information came from. I was told by Roderick Williams and Jarnell Singh that the report was privileged parliamentarily and that I should ask for its... I gave my advice
Yep.
On the back of them telling me that Parliament were going to get the report on the 1st of July.
Yep.
In the end, I don't think they did, but that's what I was told. And I was asked, could you apply for a certificate because it was privileged? I think, I can't remember the exact wording, but the wording was along the lines, I paraphrase, because we can't publish it before Parliament has authorised it.
And that was both Roderick Williams and Jarnell Singh that you spoke to?
I spoke to both of them about it.
Spoke to both of them. They both asked you to make an application for public interest immunity.
Post Office asked through them. I don't think you can say they both asked me. That rather suggests that each one separately asked me. I don't think that's the position. I was asked by them jointly on behalf of Post Office to make the application.
Right.
That's what I did.
As counsel, trial counsel as it was, trial starting 1st of July, same day you make the application. As trial counsel, what were the legal principles that underpinned your approach to how public interest immunity might operate in those circumstances?
Well, I followed the case of R&H, R&C, which sets it out very clearly. Those
help
were
me
the
as
principles
to
I applied.
help me as to how that might apply from H&C.
In what sense?
Well, what part of H&C do you suggest allows you to make an application on the basis of parliamentary privilege?
Matter of national interest.
Matter of national interest, right, OK. Now, there's no express mention of parliamentary privilege in your post-hearing attendance note, is there?
No.
No. So can we just look, if we just to make that clear, paragraph 14, please, which is on page, if you give me a moment, I'm sorry, page 6 of 9. And we see there, and this is obviously from a distillation of your understanding of the principles set out in H&C, possible to apply to a judge for a certificate, most often occurs in cases involving national security, but the list is not closed, and where the public interest may be the prevention of a widespread loss of confidence in a public institution, etc., then that is your basis, but there's nothing there about parliamentary privilege, is there?
No, that's the consequence of breaching parliamentary privilege in this case. That's what would happen if I didn't apply for the certificate. And I reiterate that if the application was in any way improper, the judge would not have granted it.
Well, those are the consequences of a breach of the publication of the report. There is no mention of the consequences of a breach of parliamentary privilege in there, is there? There's no mention.
If your suggestion is that I was not applying on the basis of parliamentary privilege, then you are mistaken.
Well, let's not bother about suggestions, please, Mr. Clarke. Can we go on to paragraph 16? And here we see, in this case, I took the view that such an approach to the problem might be appropriate. And this links into paragraph 14. And there you are saying that with Jarnail Singh, you took the view that the best way forward is to seek a ruling, grant a PII certificate, that we need not disclose to the defence the fact that the second sight report was to be presented to Parliament today, and that the report contained references to the existence of bugs in both Horizon past and present, and to adjourn the trial. So no mention again there of parliamentary privilege. And then at paragraph 24, we see that it's worth commenting on the reasoning behind my advice that we seek a PII certificate in this case. Post Office were rightly, in my opinion, very concerned at the potential adverse publicity which would inevitably have been generated by the revelation of the existence of a draft second sight report, to permit this information to enter the public domain, etc., etc. Such speculation would have seriously damaged the reputation of Poll and would have greatly undermined public confidence in both Poll and Poll systems. Our objective was to avoid such consequences. That objective was achieved. Again, nothing about parliamentary privilege and the consequences of breaching parliamentary privilege other than, essentially, it's not going to be great for Post Office.
I disagree with your characterisation.
Well, where is there any reference of the consequences of breach of parliamentary privilege, if there is even obliquely, over and above the interests of Post Office?
It's not in that paragraph and it's not in the document. That does not mean that was not the basis upon which I approached it.
I haven't suggested that, Mr.
Well, I think you have.
I'm just asking you why it's not there. Why isn't it in there?
An oversight, a mistake, I don't know, but it's not there.
All right, and then just to complete this, if we could look at paragraph 18, please. We see that the judge, His Honour Judge Chambers, was ultimately persuaded of the arguments advanced in support of the grant of a PII certificate. And then it says, see paragraph 14 above. By implication, those were the arguments in paragraph 14 that I've already taken you to that were advanced in support of the PII application, with absolutely no mention of parliamentary privilege in paragraph 14. Why didn't you say there, for example, and of course, we based all of that on the issue of parliamentary privilege?
Looking back, I can't say.
Right.
But the judge granted the certificate.
Yeah, and therefore it was appropriate if the judge granted the certificate.
Well, of course.
Right. In any event, you say that parliamentary privilege was the basis for your application in respect to the second sight report. Now, you had received information directly, both from Gareth Jenkins and from Post Office, hadn't you, prior to this hearing?
Yes, I'd explain that.
Yep. But you hadn't seen the second sight report.
No.
You'd received information from Gareth Jenkins. If we could look at, please, paragraph 7 of the report, just going up the page. And just at one, he'd informed the second sight committee of 2 bugs which had affected Horizon. So that had been provided to the second sight committee. 2 bugs had affected Horizon. He told you that.
Yes.
He told you directly that. And then at 5, if we could, please, we've got the other matters there. It's his view that were the defence to suggest a problem with Horizon, he cannot rule out that there may be other problems with Horizon. Yes?
Yes.
And we saw as well, we no need to go there for time reasons, but at paragraph 6, a whole lot of information was given to you by Post Office, directly, not looking at the second sight report.
I never said that.
Well, let's just have a look at paragraph 6, please. At the top. Yep. On the 27th of June and through the following day, I was instructed that a number of post offices, the Horizon system may have produced false balances. I am, however, informed of the following, and then you set out your instructions in relation to information from Post Office, so as 2, Horizon is not bug-free. Going down, and this paragraph 6, without going through all of it, 4, a number of bugs have been identified, and then going down to the 8, Hurst Lane is not one of those post offices identified as having been affected, but you've received information from Post Office about what has been discovered, haven't you?
The reason I objected to your question was because you said a lot of information had been given to me.
All right, okay.
It hadn't. The information that had been given to me is recorded here and is about 2 bugs, neither of which affected the Hurst Lane office.
Well, you've had information from Post Office and you've had information from Gareth Jenkins directly, and you've been told by Post Office's expert that he had informed the Second Sight Committee of 2 bugs which had affected Horizon, and it's his view that were the defence to suggest a problem with Horizon, he cannot rule out that there may be other problems with Horizon.
That's the information I was given.
Why wasn't that immediately disclosable to the defence?
Because I had to wait for the publication of the Second Sight report.
Why did you have to wait for the publication of the Second Sight report when that was information which undermined the prosecution case, which was known to you from the expert commissioned by Post Office, who was the expert in Post Office's prosecutions, that had come directly to you from him? Why wasn't that immediately disclosable?
Because I wanted a PII. We're going to go around in circles here. I wanted a PII certificate on the instructions from Post Office to suppress the publication of that material until such time as Parliament had seen and released the document from whence this information comes, and I wanted time, as I explain in the document, to consider my disclosure duties before commencing on a trial, and in order to do that, I did not commence on a trial, and in due course the material was disclosed within a matter of weeks.
That had nothing to do with the Second Sight report, did it, other than the fact that what their expert had directly told you was disclosable, it was there and would eventually end up in the Second Sight report. That was the view of the expert, which was disclosable, wasn't it?
That is an opinion you advance. I took the view that what the expert told me was what was contained in the Second Sight report.
Thank you, sir.
Just my memory may be playing tricks on me, Mr. Clarke, but my recollection of having made and adjudicated upon PII applications, that although they're done without the presence of the defence, they are either recorded by a shorthand writer or electronically.
Yeah, I think
was
that's
this
right.
one recorded?
I can't say specifically. It should have been, and I.
But that would be your expectation. That
Oh
it would
yes,
have been
absolutely.
recorded.
I certainly didn't ask for it not to be recorded.
Fine. All right, that's all.
So if
Thanks.
it did assist, the evidence of Mr. Smith was that it was recorded.
Right,
he
and
was
I'd forgotten he said that. Sorry.
Thank you. It's
Mr. Begg.
Mr. Clarke, I've got a few questions for you. Can I take you immediately to a document which is POL 406365? It'll come up on your screen in a moment. And we can go to the bottom of the document, but I'm not going to ask to do so. If you'll take it from me, the document's dated the 8th of July 2013. Okay?
Yep.
Right. So the sequence of events that relates to Mr. Jenkins and your concerns about his evidence that he's misled the court, that's what this is. So the sequence of events is this, that on the 27th of June, Martin Smith told you about an unpublished report, the Second Sight report, which stated there were bugs in the Horizon system.
That's correct.
You've given your evidence earlier that you were very concerned and you wanted to find out who told them that.
Yep.
Okay, so that's those events. That then led you on the 28th of June with Martin Smith to have the telephone call that you've given evidence about that was recorded with Gareth Jenkins. Okay, so far?
Yep.
All right. Now, in between that time and the 15th of July, the Jenkins advice, the Clarke Jenkins advice that we all call it, you wrote this advice, the one that's up on the screen,
Yep.
which is dated the 8th of July. Okay. Now, it says under paragraph 1.1, alternative Fujitsu expert. I suggest Fujitsu be told something in the following terms, that he's, Mr. Jennings, it says here, Jenkins has provided expert advice in a number of poll prosecutions. He was involved in the Second Sight process. And then it goes on to say, basically, counsel has advised poll that there ought to be at least 1 degree of separation between any expert witness called in support of poll prosecution and the SS process. Okay? Just help us understand what's going on here. By this point, do you agree that you had come to the conclusion from the telephone call that Mr. Jenkins had misled the courts?
I'd come to the conclusion that he'd not fulfilled his duties as an expert witness as he should have done.
And as we understand it from your subsequent advice, when you came to write that, your conclusion at that point
Yes.
was that he had not provided truthful evidence about his knowledge of bugs to a court or in his statements to courts. Is that right?
I'm being careful about not
Sure.
providing truthful
Yeah.
evidence because I'm not a judge of his position. I don't know why he did
Okay.
not do what he did. I had come to the conclusion that he had not complied with his duties as an expert witness, and I think I make that very clear in my 15 July advice.
You do, but this is quite serious. It's something that can't be ignored. You've got to do something about it. Mr. Smith said of you that you have a bit of a tendency that does make sense to write advices, to write documents, to record your thoughts and your advice.
Yes.
Is that right?
It
It's what
is.
you tended to do.
It is.
And we can see a series of advices that relate to that appear to show that you do exactly that.
Yes.
Okay. So where we're looking at this particular advice, general advice here, saying alternative Fujitsu expert, can you help us understand why it doesn't say on the 8th of July, there are some really worrying things about Mr. Jenkins. Maybe I'm still processing it, but we need to tell Fujitsu that there's a real hole opening under Mr. Jenkins and Fujitsu's feet.
Because
Do you follow?
No, I follow the question.
Yeah.
I hadn't at that point come to that definitive conclusion. I was still processing stuff. I had formed the view that at this point, 8th of July, I'd formed the view that Gareth Jenkins could not and should not be a witness in the future, not just because of the faults that he had alluded to, but because he was an employee of Fujitsu.
Right. So what we're getting layers of this. You're processing what's going on in relation to Mr. Jenkins. You've come to the conclusion by this stage that there needs to be an independent, truly independent expert, not someone from Fujitsu.
Yes.
Then you get the 15th of July advice whereby things have become more concrete in your mind and you're more trenchant, a word you used earlier about matters that relate to Mr. Jenkins. Is again that fair?
That's fair.
After the 15th of July, is Fujitsu told what has happened and your trenchant thoughts about Mr. Jenkins?
I don't know.
Right. Did you, just to help us a bit further, did you advise that Fujitsu, the employer of Mr. Jenkins, should be told what you've discovered?
I would have said it already to Roderick Williams. I may be wrong, you may find something. I don't know whether I put it in writing or not.
Okay, so you just don't know what's happened in relation to Fujitsu?
No.
And you don't know whether the impression that was left in this advice, which is only to tell Fujitsu about an independent expert needed, you don't know whether that was ever corrected into, oh my God, there's a real problem with Jenkins?
No, I don't.
Okay, fair enough. When Mr. Altman came on board, in relation to you, quite a much more senior barrister, or Silk at that time, someone with considerable experience, with lots of quality assurance tags around him. Treasury Counsel, Senior Treasury Counsel, First Treasury Counsel. He's a very, very well-known individual. Did you have a discussion with Mr. Altman when he first came on board, saying to him, I've never seen anything like this. We've got this expert. He's not, it seems, been candid with the courts in statements and his evidence. We don't know why, but surely we should investigate this. Did you have that discussion with Mr. Altman?
He knew about it.
Yes.
Because he had seen my advices. Did I have a specific discussion with him about this subject? It seems unlikely that I wouldn't have done.
Quite.
But I don't recall one. In terms of the other theme of your question, which goes, did you think it ought to be investigated? It's not my function. I did not see it then as my function to conduct an investigation into whether or not Gareth Jenkins was an honest or a dishonest witness. That was the role of Fujitsu and Post Office.
Okay, fine. And you agree with me that by the time you've reached the 15th of July advice, and that has then gone to Mr. Altman, that the position seems to be that Martin Smith is aware of the problems with Jenkins, putting it neutrally. You obviously are as well, because you've written the advices that we've now been looking at, and Mr. Altman is now on board.
Yep.
But nobody seems to say that this man needs to be investigated.
I don't think you can say that. I don't know what was going on in Post Office. If your question is, did any of the external lawyers, you've named them, Smith, me, Altman, have that conversation? I don't believe we did. And I don't believe we did because we would, and I'm convinced that Mr. Altman would have taken the same view, it's not counsel's function to conduct an investigation into the propriety of a witness.
I don't mean to cut you off, Mr. Clarke. I just want to just get to the final part so that we conclude, other people can then take over. Right. Now, our work as barristers, particularly criminal barristers before the court and solicitor advocates before the magistrates' court and Crown courts and so on, right? If we make a mistake and we mislead the court and it's an error, what do we normally do about it? We
confess. We tell the court we've made a mistake. Yes.
We immediately do so, don't we?
Yes.
And I don't know whether you're like me, but in that situation, we've all done it. We've all made errors. We've all unknowingly, unwittingly come to say something that then turns out to be wrong, or we've made a mistake. And frankly, if you don't correct it, it makes you feel, you know, don't correct it immediately. You're worried about it, aren't you?
You don't correct it immediately, you're guilty of professional misconduct.
Well, quite. And so what you try and do is, as soon as it is possible, at the right moment, to intervene with the judge, to say, look, there's been this problem, you put your hands up and you say sorry, and you try and explain, if you possibly can, why. Is that fair?
I agree.
Right, OK. Now, in the situation that we've got to with Mr. Jenkins, we've reached the conclusion by the 15th of July that, for whatever reason, he does not seem to have told courts in statements, and then, in his evidence, live evidence, what he should have done. In other words, that there are bugs in the system. Right. So that you agree with that?
Sorry, I'm nodding. Yeah.
You're nodding in agreement with me because I'm right.
But I'm saying yes because of the short.
I understand that. OK, fine. So those courts are in an ongoing situation whereby they have not been given the right evidence by Mr. Jenkins by the time you realise that. Do you agree?
I do.
Right. Now, if that was you and you'd made those errors, you'd immediately have corrected it, yes?
I would.
All right. You're now prosecuting on behalf of the Post Office, yes?
No.
Ah, right. Why do you say at this juncture that you're not prosecuting on behalf of the Post Office?
Because I wasn't.
OK.
I was not a prosecutor.
Unwrap that, would you?
Certainly. I was not a prosecuting barrister for the Post Office. I was never a prosecuting barrister for the Post Office. I was instructed to prosecute one case, the case of Samra. That case got to trial on the 1st of July, and I stopped it, and I then stopped every other case from being prosecuted thereafter. So I was not a prosecuting barrister.
Right.
I was the barrister who stopped the prosecutions.
OK. So let's think about your duties at that juncture. Were you operating under the duties that characterise an advocate working on behalf of the CPS? In other words, someone with the higher duties in relation to prosecution, the Minister of Justice duties? No. Right. So when you were providing the advice to the Post Office in relation to Mr. Jenkins, look, there is this massive problem, really, it's a real problem, was that to a private client?
Yes.
Right. Now, thinking back in relation to this, do you think that you were right to apply what appears to be a different ethical standard to the way that you dealt with the advice regarding Mr. Jenkins by providing advice on the private client basis versus the prosecution basis?
I don't agree with the basis of your theory.
OK. Well, then help unpick why on earth a barrister that's been qualified for quite some time by this point, you didn't immediately say to yourself and to all the other lawyers involved, we've got to do something about what Jenkins has said and correct it before the court. Help us unpick it if it's not a choice between ethical situations.
My function as a barrister in front of the court is not to mislead the court. There is no circumstance in this Post Office saga in which I had misled a court, and therefore I had no duty to go back to the court and correct anything I had or had not done. This was an entirely different situation. This was a situation where I had discovered that a witness in prosecutions in which I was not involved in had misled the court. It was therefore not my function to go back to the court that he had misled and tell the court, oh, by the way, court, that witness you heard from 6 years ago had misled you. My function was to advise Post Office as to what they ought and ought not to do in the circumstances that I had identified.
OK, two last things. Do you think that that characterisation of your position is what was, if we were to try and look at it in the way that you've looked at it, what was really going on between yourself, Mr. Smith and Mr. Altman. In other words, it was advice to the Post Office rather than trying to rectify problems that have occurred with Jenkins in the past to the courts.
No, I don't agree with that at all. I was advising the Post Office on how they should deal with the problem that I had identified. And that advice consisted of reviewing the cases, disclosing the material that ought to have been disclosed, and setting up systems in order to ensure that that didn't happen in the future. That was my function.
I've, in my questions to you, built up, as you say, a sort of construct that relates to the way that ethical matters should be considered or could be considered. You don't agree with that. Did you ever have that discussion with Mr. Altman? Did you ever say to him, what are we doing here? Are we advising Post Office or are we acting as prosecutors? Did that discussion ever occur?
No, because I knew where my footing was. I was advising Post Office.
Thank you, Mr. Clarke.
Thank you, sir. Next, we have Miss Watt and Miss Allen. Miss Watt.
When you say that, do you mean they could ask questions alternatively or what?
No. Miss Watt has one very brief question.
Right,
and
fine.
move on to Miss Allen.
Yeah.
Thank you, sir. Good
Just about.
afternoon, Mr. Clarke. I represent the National Federation of Sub-Postmasters. I'll be quick. You went to Scotland in September 2013 to meet with the Crown Office and Procurator Fiscal Service. Do you remember that?
I do.
Yeah. And this was because there was to be a termination of Scottish criminal cases on the basis that Horizon was unreliable.
No, it's because the Post Office have been informed by the PF's office that that was the route they wished to take.
Now, when you went to this meeting, you knew about Gareth Jenkins, we've just been talking about that.
I did.
You knew about bugs in the Horizon system.
I did.
You knew about the second site report,
I did.
which, although it said not systemic issues, it had concerning material in it, did it not?
Yes.
And you knew that prosecutions in England had been paused.
Yes.
But despite this, a group effort of 2 lawyers from Cartwright King and Jarnell Singh, head of criminal at Post Office, you took the time and trouble to go to Scotland to try to prevent the Procurator Fiscal from terminating those criminal prosecutions, didn't you?
Yes.
And you told the Crown Office and Procurator Fiscal Service that you were getting an expert report that would show Horizon was fine, and so the prosecutions did not need to be terminated.
No, I don't agree with that.
Why don't you agree with that?
We told the Procurator Fiscal's office that we had concerns about the existing expert and that we were hoping to instruct a new expert. Clearly, that new expert, Post Office hoped, would identify that Horizon was sound, but
Of course, it never materialised, did it?
Well, sadly not. But I've explained why not. But the space around that instructing of the new expert was to be wide. The new expert was to look at all aspects of Horizon and determine whether it was working improperly as well as properly.
Of course, you were very pleased at the end of that meeting to note you'd achieved the objective. Prosecutions in Scotland would not be terminated after all.
We didn't think they ought to be terminated because we thought that they ought to be approached on a case-by-case basis, and that was what I sought to persuade the PF's representative ought to take place. And if you look at the note that was the result of that meeting, it explains very carefully that that is in fact what the PF's office agreed to do. They agreed to look at it on a case-by-case basis, and the reason we advanced that proposition was because not all prosecutions were Horizon-based, and I've given the example already of the postmistress who was loaning Post Office money to family members, and I think that might even have been a Scottish case. And I took the view, and I suspect if I'd have put it to Post Office, they would have taken the same view, that it would be wrong to stop a prosecution in a case like that.
Well, taking all of what I've put to you together, I'm suggesting to you that collectively you were all, at the very least, disingenuous in the way you sought to persuade a Crown Office officer, a representative of Scotland's most senior law officer, the Lord Advocate, not to terminate such prosecutions. Would you accept that?
No, of course not. That's a preposterous suggestion.
Thank you.
Clarke, I represent Scottish Core participant Susan Sinclair. During your evidence, both written and oral today, you have mentioned the 2-stage process for disclosure as governed in England and Wales by the Criminal Procedure and Investigations Act 1996. What is or was your knowledge of the relevant continuing disclosure and revelation obligations of specialist reporting agencies such as POL in Scots law?
Such as who, sorry?
Post Office Limited.
None.
There is no continuing duty of disclosure?
No, you asked me what my understanding was, I think.
What is your understanding?
I had very little. I don't know what the duties were of a Scottish prosecutor.
And what I'm asking you is what the duties were of Post Office as a specialist reporting agency in Scotland in terms of disclosure.
Oh, to inform the PF's office of everything that they knew about.
And were you aware of anyone within Post Office's legal department, or indeed the relevant team at Cartwright King, who is qualified to advise on issues on Scots law?
In Qualified King, in Cartwright King there was nobody qualified. I don't know what the position is or was in Post Office.
Would you consider, if there wasn't anybody in Scots law qualified, that this was perhaps an oversight by Post Office?
Well, my understanding of the position was that you could not bring a private prosecution, which essentially is what we're talking about here, in Scotland. You had to be an appointed specialist or similar to bring the matter you're concerned with to the attention of the Procurator Fiscal, and the PF would then be responsible for conducting the prosecution. That was my understanding of the process. Whether or not Post Office understood that or not, I don't know.
Thank you. Did you or the Post Office disclose your advice document regarding Gareth Jenkins' reliability as an expert witness? For the record, that's POL 406357. Or share your concerns with your counterparts in the devolved jurisdictions, such as the Crown Office and Procurator Fiscal Service in Scotland in July 2013?
That's forgive me, a two-part question. The first part of the question, did I disclose my advice? No, I wouldn't have dreamed of disclosing my advice. It was privileged, and it was privileged to Post Office. Whether or not Post Office disclosed it, which was their right or not, I don't know. That's the first part of your question. In terms of the second part of your question, I'm afraid you're going to have to remind me of it, sorry.
It was whether you shared your concerns as to the reliability of Gareth Jenkins.
Yes, I did. If you look at I don't know what the poll reference number is, but there's a note from BDO where they conducted a meeting with, I think Martin Smith was involved, and a representative of the Procurator Fiscal's Office, in which they discussed the issues about Gareth Jenkins.
And do you recall when that was?
I think it was a day or so before the meeting I had with the PF's office.
Okay, thank you.
It's in the papers, and it very clearly says that BDO told the PF's representative about Gareth Jenkins.
Okay, thank you. And during your involvement with the Post Office, were you aware that the Post Office had instructed a Scottish firm, BTO Solicitors?
That's who I'm referring to, BTO, yes.
Thank you. And what was your understanding of the instruction of BTO Solicitors?
I don't know.
Okay. And was BTO represented at meetings with Post Office, Cartwright King and the Crown Office and Procurator Fiscal Service in Scotland?
I think Martin Smith acted as a sort of liaison between Post Office and the PF's office and BTO. I had very, very little to do other than the meeting with the Scottish aspect, or indeed the Northern Ireland aspect of this thing. I was concentrating on England and Wales.
Thank you. I know Miss Watt had touched upon this, but I want to just touch upon your contact with the Crown Office on the 4th and 5th of September 2013. Was this meeting at Crown Office's request as opposed to the Post Office's?
I can't say.
And you refer to the purpose of this meeting with the Crown Office in Scotland being to see if anything could be done to dissuade it from the stated course of terminating all Post Office prosecutions in Scotland at this time, not just those relying on horizon-based evidence, due to concerns of a public relations storms for Post Office.
So I missed the last bit of that. Just
due to concerns of a public relations storm for Post Office.
No, I don't accept that.
I'm sure that's in your witness statement, but you go on in your witness statement at paragraph 57 to say you were ultimately successful in persuading it to review each Post Office case and make a decision on the basis of each individual case. Was this approach not contrary to your advice to Post Office in July 2013 that all ongoing or future prosecutions should be put on hold until an independent expert had been properly identified?
No, that's what I was asking the PF's office to do. To put the PF's office were proposing to stop everything, to stay all of the prosecutions. I was asking them not to do that. I was asking them to do what we had done in England and Wales, which is to suspend or what's the word? Just stop the prosecutions to the extent that they should be considered on a case-by-case basis before determining whether or not they ought to be discontinued. Because to the minds of Post Office and my mind, it would have been wrong to stop prosecutions where the allegations were not dependent upon Horizon. And I've given an example as to where that might be the case. That was my aim, and that is what I achieved.
At paragraph 194 of your witness statement, you describe being professionally and personally proud of the fact that you stopped POL prosecutions from 2013 onwards. We know now that there were up to 60 prosecutions in Scotland between 1999 and 2015 involving Horizon evidence, some of which were brought after your meeting with Crown Office in September 2013. Is it not the case that actually the Crown Office and Procurator Fiscal Service was eventually responsible for making that decision in Scotland?
I never claimed to have stopped the prosecutions in Scotland. I claimed to have stopped them in England and Wales, which was the primary jurisdiction with which I was concerned.
If I refer to your witness statement, you stopped all POL prosecutions from 2013 onwards.
Yes, in England and Wales.
But rather, in Scotland, you'd engaged in a course of actively seeking to dissuade the Procurator Fiscal from continuing in September 2013. And this was perhaps, would you accept, a missed opportunity and caused undue delay in putting a halt to Scottish prosecutions?
No, I don't agree with your characterisation of what took place or what I said. What I said was I was proud to have stopped the Post Office prosecutions. I was referring to the England and Wales jurisdiction. I had no power or authority or to even advise or stop Scottish prosecutions. That was a matter entirely for the Procurator Fiscal. And so, no, I don't accept your thesis.
Okay, thank you, Mr. Clarke.
Thank you, sir. It's Mr. Henry next. We have Mr. Henry and Miss Oliver left.
Sir, may I raise something very quickly? With great deference to you, sir, to whom I express my gratitude. But Miss Oliver and I have a substantial number of questions, and I fear that it is simply not possible to conclude by 4:30. In fairness to Miss Oliver as well, and I raise it now without, I hope, any impertinence, but simply to apprise you, sir, of the gravity of the matters that I have to put to this witness, and also, of course, the fact that Miss Oliver has a number of very important matters to address.
I appreciate that. Well, can I take it that your questions relate to one or more of your clients, first of all?
They do.
And in the main, is it Miss Misra?
It is Mrs. Misra.
Yeah. And does it relate essentially to the conduct of the reviews in her case, or is it wider than that?
It's wider than that.
Well, if you just start, if you would, with the wider than that, and let's see where we're going.
Yes. I want to understand your status. Were you advising the Post Office as a corporate, or were you acting as part of a firm of solicitors that had effectively taken on board their entire prosecution facility and service?
I think the latter is a proper characterisation.
So the latter is the proper characterisation, and we know, and no need to take you to them unless you specifically wish to, that you were aware of potential civil claims.
At what point are you referring to?
2013, July.
Yes, that's likely.
Yes. You were aware of potential civil claims, and in the course of that quarter between July and September, you had written some extremely accommodating advices to the Post Office, stating that they would not be liable for malicious prosecution. The responsibility would fall on Cartwright King.
I don't agree with your characterisation about extremely accommodating. I wrote advices as I saw the position to be.
Well, it is extremely accommodating to say we'll throw ourselves under the bus for you, isn't it, Mr. Clarke?
I don't agree with you.
And a curious thing that, in fact, they asked you to write a second advice on the 12th of September 2013 because they probably couldn't believe their luck, Mr. Clarke. You, on behalf of your firm, were basically saying, we will take the rap for malicious prosecution. POL will be completely absolved from responsibility. What were the pressures on you, Mr. Clarke?
I'll answer the first point first. You are wrong. And the second point is there were no pressures on me, and I'm not resistant to pressure.
Well, we'll see about that.
I won't take pressure.
I'm afraid I'm not wrong, and therefore I'm going to put onto the record for you, sir, to review in due course POL 00114253, 12th of September 2013, and POL 001-98766, the 12th of September 2013. But anyway, you accept that...
Let me make sure I've got those correctly, Mr. Henry. 00114253 was the first.
That's correct, sir.
198766 the next. And are they...
Sorry, 198766 the next, after 2 zeros.
That's it, yeah. And are they both dated the 12th of September?
They're both dated the 12th of September. They're both written by this witness.
Yeah, thank you very much.
Right. So, you're advising the corporate. And you have already given answers to Mr. Steen this afternoon that you didn't feel under any obligation at all to inform the solicitors of a woman who had gone to jail whilst pregnant because it was nothing to do with you.
I don't think that's what I said.
Well, that's the gist of what you said, isn't it?
That is not what I said. I am not interested in gist. I'm interested in what I said.
Well, then what did you say?
You know what I said. You have it on record.
Do assist us. Just tell us what you said.
I said that I did not think that Mrs. Misra ought to have disclosure of the documents.
You're aware of your duty, aren't you, where after the conclusion of proceedings, material comes to light that might cast doubt on the safety of the conviction, the prosecutor must consider disclosure of such material. You were aware of that?
Yes.
Yeah. You had a positive duty either as part of the firm or to advise the corporate that disclosure must be made to Mrs. Misra as soon as possible.
You've had my advice, you've seen it, you've read it. That was my view at that time.
I'm going to ask you, please, to reflect on the 9th of September 2013. You attended a conference at 2 Bedford Row together with Bon Dickinson, members of the Post Office, to see Mr. Brian Altman. Correct?
Yes.
Right. Mr. Altman called in 1981, just stood down as first senior Treasury Counsel, lustrous reputation. Did you rely on him, take a steer from him?
Of course.
Yes. You were called in 1997. According to your website, you've had a high-level criminal defence practice for over 25 years. So by 2013, you'd have had 16 years' experience.
Yes.
Right. It is inconceivable, I suggest, that you would have failed to recognise the relevance of your conversation with Mr. Gareth Jenkins on the 28th of June, which you distilled in your Clarke advice of the 13th of July 2013, or 15th of July 2013, it is inconceivable that you would not have recognised the importance of disclosure to Mrs. Misra.
Forgive me, is that a question? Are you asking me whether or not I agree or disagree with the proposition?
Take it as that.
Just answer.
Beg pardon?
Take it that that is the question.
Thank you. I disagree.
You disagree. You would have keenly appreciated the vulnerabilities of Jenkins as a witness, whom you described as fatally undermined, and you would have known the role that he played in the conviction of Mrs. Misra, and you did know the role that he played in the conviction of Mrs. Misra by the 9th of September 2013.
Yes.
And so did Mr. Altman, didn't he?
I imagine so.
Yes, because you know that he had read all of the papers by the time you arrived. Now, let me just ask you this. If you were counsel for Seema Misra, what use would you have made of the material that you then knew, Mr. Clarke?
I wasn't counsel for Mrs. Misra.
Oh, come on.
I wasn't counsel for...
You understand what I'm saying. You have to look at the position of what the material would do if placed in the hands of competent counsel. Don't evade. What would you have done?
I wasn't counsel for Mrs. Misra, and I cannot answer that question.
You know perfectly well that it would have given rise to an irresistible appeal, don't you?
I know that's what would have been the outcome, but that was not your question.
You're splitting hairs, Mr. Clarke. You know that it's inescapable. You know that the material that was inside your head was absolutely dynamite. It was a bombshell, and it would have given rise to an inevitable appeal for Mrs. Misra as soon as it had been notified to her.
What I know is that I advised that the material ought not to be disclosed, and that I now accept that that was an error.
We'll come to that. I'm asking you now about the 9th of September, because I've looked at 2 notes of that consultation with Mr. Altman, and it doesn't seem that any discussion either around the damaged or tainted status of Mr. Jenkins and disclosure to Mrs. Misra arose at that conference in either of the notes.
If you're asking me, was there such a discussion, I believe there was.
Right. So therefore it follows that there must have been a discussion, as you say, you believe there was, and obviously the discussion resulted in saying, we're not going to give her anything.
I'm not sure that's right. At some point, Mr. Altman pointed to my January advice and said, I paraphrase, that's wrong, you ought to disclose.
I'm talking about the 9th of September.
Well, if I can finish my answer, I don't know whether or not that took place on or about the 9th of December or after.
Let us go, please, to your knowledge of the civil, because you would have realised, wouldn't you, that if Mrs. Misra had appealed, it would have undermined the defence of the civil claims.
I had nothing to do with the civil claims, and I had, at that time, almost no knowledge of civil law other than what I'd learned at university years beforehand.
You already conceded to me that you knew about the civil claims when I put that to you.
What I said was I wasn't part of them.
Yeah.
I had no role in the civil claims.
Sorry to be pedantic. At the point in time that I thought we were talking about, the September 2013, there were indications of civil claims, as I understand it, in that a firm of solicitors had indicated a possibility of it, that is Shoesmith's.
That is correct, sir.
Beginnings of the mediation. So is that what you're talking about, Mr. Henry?
I am, sir.
Yes, so that I can be clear. Right, thank you.
Okay.
I mean, let's be clear about this. Bond Dickinson are there. What were Bond Dickinson doing at the conference or the consultation on the 9th of September 2013?
There came a time during that conference when, and there was another conference where it happened again, where the criminal lawyers in terms were asked to leave, and the conference continued after we'd left.
You knew that they were the Post Office's civil lawyers?
Oh, yes.
Yes.
Yes. And that's why I assumed we were asked to leave.
Yeah. And you said earlier today that you should have asked the question why there were the transcripts of the Misra trial. Do you remember saying that?
Yes, I do.
Well, we can give you an answer for that, and maybe you've already become aware of it by watching the inquiry, because on the 16th of December 2010, Miss Talbot wrote an email to Mr. Singh saying that the Misra transcripts will help with the civil actions. I ask you again, were you not aware of the unique and special importance that Seema Misra's case formed as a precedent to deter civil and criminal claims?
The first knowledge I had about the email you've just referred to is when you just told me just now. I didn't know about the existence of that email, or that was how the transcripts came into being. The first I knew of the transcripts was when I was sent the transcript of the summing up in, I think it was December 2013. Frankly, what you've just told me reinforces my view that I was drip-fed the Misra file over the following year.
Well, we'll come to what you were given in December. But you were aware, were you not, that Mr. Altman advised that Cartwright King be kept fully informed of the civil litigation?
I don't know. If you say so, then that must be right, but I don't know. I took no interest and no part in the civil litigation.
Right. Now, if I were to put to you that Mr. Altman, by one way or another, had his instructions chamfered so that responsibility to advise on Seema Misra's case fell squarely upon Cartwright King, what would you say?
I'd be surprised. It's new to me if that's what happened. Right. And frankly, from what little I know of Mr. Altman, I'd be surprised if he accepted that sort of pressure.
You did gather, however, what his approach was to the Misra appeal. Would you agree?
I don't understand what you're referring to. You say his approach to the Misra appeal. You'll have to expand. I'm sorry.
Right. Well, if I were to put to you that during the consultation on the 9th of September, he expressed concern that the slightest apology to a convicted person or the payment of compensation could indeed give rise to an appeal, and he was concerned that Misra would use the mediation scheme to obtain some concession to allow her appeal.
Is that what it says in the note?
That is what is said in a note sent by Mr. Smith to Susan Crichton following the consultation.
I know nothing of that note.
But you were at the conference.
I was.
You knew that Mr. Altman was saying that he was worried that other Misras would crawl out of the woodwork and that you shouldn't mediate with Mrs. Misra under any circumstances.
I don't agree with your use of the phrase crawl out of the woodwork. I think that's offensive to those who were convicted.
I'm quoting from a note.
Well, maybe so, but I still don't approve of it.
Right. There we are. So what I'm suggesting to you is that you were fully cited on the importance of Seema Misra's case, and that if Seema Misra's appeal succeeded, it would cause pandemonium for the Post Office, wouldn't it?
You're wrong about that.
Why am I wrong?
I was not fully cited.
Well, you were certainly aware of the civil litigation.
I've told you, at that point I was not. I've already explained that. I took no part in the civil litigation, and I was not aware that there was any pending civil litigation in September 2013.
But you've been sent, Mr. Clarke, and you've advised upon it. You've been sent on the 11th of December 2013 an attachment which talks about civil claims against the Post Office, and you were asked to advise on it.
And you were asking me about September 2013.
Well, I was talking then about Bon Dickinson being at the consultation.
Well, I'm sorry, you didn't make that clear. I did not know in September 2013 of any pending civil litigation.
Do you agree or do you disagree with the fact that Mr. Altman advised that the firm Cartwright King be kept fully informed regarding civil litigation?
I can't say.
Right. Well, is it that you can't remember or that you choose not to answer?
I find the second proposition offensive. The
Forget any construction on it. Just answer the question.
I did. You offend me when you suggest that I'm not being truthful.
I'm going to suggest to you that it is absolutely impossible that you could have advised in the way you did, given your experience, because let's look at the position. You knew that Horizon was essential to Mrs. Misra's conviction on theft, didn't you?
I'm sorry?
Sorry, Henry, could you stop a second, please? Yes. Let's get it out into the open. Are you suggesting that the two, I'll call them reviews of whether or not disclosure to Miss Misra, are you suggesting that those two reviews were written in the way that they were for a completely ulterior motive and an improper motive, as opposed to being an assessment, whether right or wrong, about whether disclosure should be given?
I'm trying to explore with the witness how he could have reached such an untenable conclusion, sir, which...
Right. Well, he says he made a mistake. Those are my words, not his. If you're going to suggest to him that it's something more than that, then put it in the form of a direct question, and then we can move on.
Were you part of the suppression of material that would have allowed Mrs. Misra to appeal promptly to the Court of Appeal?
No, and I think the suggestion that you put to me is a disgraceful one.
Well, then I must explore with you, therefore, you wrote the Grant Allen advice on the 16th of July 2013. Do you remember?
I don't.
You don't?
No, I wrote many advices. You can't.
I'm going to quote from it, and if you would like to have it put up on the screen, by all means. But I'm going to quote from it first. In a case where we have relied upon Dr. Jenkins as to the efficacy of Horizon, we are bound to disclose material which undermines his status as an expert witness. You wrote that on the 16th of July.
I accept that.
Yeah. How on earth could you have reached a different conclusion with Mrs. Misra in January of 2014?
Because I was talking about Horizon Online cases in which Gareth Jenkins had provided witness statements. Mrs. Misra went back to pre-Horizon Online. And at that point, we weren't looking at pre-Horizon Online.
But you've already said that you were aware of bugs. You said that to Mr. Blake, that you were aware of bugs in old Horizon as well.
Yes, but I was looking at New Horizon.
Yeah. But let's just concentrate on this. You agree that Horizon was essential to Mrs. Misra's conviction on theft?
Legacy Horizon.
Legacy, yes.
Yes.
Okay. Horizon could have additional bugs, Mr. Blake asked you, and you answered old Horizon as well. We did. So, are there bugs in Horizon? Your answer would be yes, wouldn't it?
Yes.
Right. Horizon Online, obviously, yes, but old and legacy Horizon, yes.
Yes.
Right. Was Horizon Online developed to replace a less robust system? You would agree, yes, wouldn't you?
I have no idea.
Right.
I'm not a computer expert.
Well, let us move on then. Did we, the Post Office, say at Seema Misra's trial that everything was fine, bar one irrelevant, rectified Falkirk bug? Yes. Correct?
Are you quoting me?
No, I'm just putting you the question. Did the Post Office say or claim at Seema Misra's trial, through Gareth Jenkins, that everything was fine, bar one irrelevant rectified Falkirk bug? Your answer would be yes.
I can't say. Without going back to the documents, you're talking about a trial I took no part in years before I was anything to do with Post Office. I can't say what was and was not said at the Seema Misra trial today.
But you knew this, didn't you, Mr. Clarke? You knew that the person who gave evidence against Seema Misra had failed to disclose the existence of bugs, errors and defects.
Yes.
You knew that he had given evidence to the contrary.
Yes.
And you knew that he had put the Post Office in breach of its duty as a prosecutor.
Yes.
How on earth, therefore, did you advise that she should not get disclosure when you advised in January?
I think you'll find that I've already accepted that that was an error on my part.
What happened, I suggest, is that eventually only the Second Sight interim report and the Helen Rose report was handed over to the CCRC in 2015. That's correct, isn't it?
I don't know what was given to them.
Right. The Second Sight interim report just expressed the existence of bugs, but not that someone had lied about them and misled the court. You would agree with that?
That's what the interim report that I saw said, yes.
Yes. So the critical factor of lying and misleading the court was not within the Second Sight interim report or the Helen Rose report.
No.
No. Again, I ask you, how could you, an experienced barrister, have come to the conclusion, having expressed the view in December that she should get disclosure, and in January you said she should not?
Well, just as Mrs. Stein suggested earlier, we all make mistakes, and I've accepted I made a mistake.
You offered as an explanation, as rationalisation, that you only had the transcript of the summing up at the time you wrote the December document. Do you remember?
I've told you that was the fact of the position.
Well, that is not what you write in the December document. In fact, in the December document, you don't say transcript of the summing up, you say transcripts of the trial. So you had clearly read the transcripts of the trial, paragraph 33 of PO of Poll 001 98595. You had clearly read the transcripts of the trial by the time you wrote that advice on the 5th of December, hadn't you?
I disagree. And my disagreement is consistent with the writing of the 20th of January 2014 advice and the few email.
And that few email, obviously one recognises the explanation you gave, but are you sure that you were not put under pressure because you knew the central foundational, that she was the foundation stone, the Seema Misra conviction, for deterring civil claims and also deterring criminal ones?
I've already told you that I do not accept that contention. I did not have that knowledge, and that is not, and I was not placed under any pressure. And I would add, had anybody sought to place me under pressure of the sort you describe, I would have immediately withdrawn.
Right. Can I just ask you then, in conclusion, to go back to the 9th of September 2013, and you've read, presumably as part of the information pack, the notes of the consultation taken by your colleague, Mr. Smith.
Yes.
You have. There was no investigation, as you have already explained to Mr. Steen, because you didn't feel that it was appropriate, into why Gareth Jenkins had done what he did, correct?
Correct.
Can you offer any explanation how Mr. Altman came to the conclusion, as is reported in the conference, that it was more to do with incompetence than dishonesty?
No. You'd have to ask him that question.
Thank you, Mr. Henry.
Thank you, sir.
Right. Now then, we have one questioner left. First of all, a time estimate, please, Ms. Oliver.
Well, sir, my time estimate to Mr. Blake was 30 minutes. I think truncating things, I could do it in 20. I think I might struggle to do it in 9.
No, that's fine. Transcriber, if we have another short break, are you prepared to sit on for 20 minutes to complete Mr. Clarke?
We have a
Not
thumbs up.
pressure on you. It's entirely for you to tell me what suits you.
We have a thumbs up, sir.
We have a thumbs up. So we'll have a 5-minute break and then we will complete Mr. Clarke, which will make him happy as well, by 10 to 5.
Thank you, sir.
Yes, Ms. Oliver.
Thank you, sir. Good afternoon, Mr. Clarke. I ask questions on behalf of Mr. Jenkins. I'm going to take this as quickly as I can.
I know
okay?
you will. Thank you.
We've heard from your colleague at Cartwright King and later business partner Martin Smith, who indicated that at or around the time of your 15th of July 2013 advice concerning Mr. Jenkins, he came to the conclusion that neither Post Office nor Cartwright King had ever instructed Mr. Jenkins as to his expert duties. Do you remember that aspect of his evidence?
From what I know now, I know that to be the position.
All right. Is that a conclusion that he discussed with you at the time?
No.
When did you come to your conclusion about those failings on the part of Post Office and Cartwright King?
In relation to whether or not Gareth Jenkins had been properly trained?
Whether he'd been informed about his expert duties?
During the course of these proceedings.
All right. We'll come on to that. Were you ever party to discussions within Post Office at the time of your advice or around that time as to the same conclusion that Mr. Smith had reached?
That he hadn't been trained?
Yes.
No.
Did you have any suspicions of your own as to the sufficiency of his instruction?
Truth is, I didn't turn my mind to it because I think, as I used the phrase earlier, I was more interested at the time in effect rather than cause.
All right, thank you. I just want to explore that a little bit further if I can. We've heard from Mr. Smith that you, he and Mr. Bowyer worked closely together as at the time of 2013.
Pretty well, yeah.
Thank you. He gave evidence that we were a 3. Would you agree with that characterisation?
No.
Would you, I think you've already indicated that you don't agree that he was content to follow your lead as someone that had more prosecution experience than him?
No. No, I don't agree.
You don't agree with that proposition? Paragraph 35 of your statement to this inquiry, you indicate that you discussed a range of matters concerning Post Office prosecutions with Mr. Bowyer and Mr. Smith, not least because shortly after the time of your July advice, you took over running the Post Office Prosecutions Department at Cartwright King.
Yes, that's right.
Thank you. And we've seen an example this morning of an email dated the 10th of July that was addressed to you and Martin Smith jointly on the topic of Gareth Jenkins.
Okay.
Do you agree with that?
If I've been taken to it, yes.
Thank you. You had also at that time come to your own independent conclusions about Post Office's competence in terms of disclosure following your meeting with them on the 3rd of July.
Yes.
Is that right?
Yes, I wouldn't use the word competence.
No, I think you say at paragraph 43 of your statement, an apparent failure by Pol to understand their disclosure duties.
Yes.
And was that a matter of concern to you?
Well, of course.
You talked this morning about Post Office and their lawyers becoming defensive when you raised the issue of expert evidence with them.
Yes.
Do you recall that?
I do.
Did that raise concerns on your part?
Yes, it did.
Again, just referring to your statement, I'm not going to turn it up if I might. It's paragraph 36. You indicate that you worked closely with Roderick Williams of Post Office during this time around your advice.
Yes.
We know from a manuscript note that you may have seen that this lack of expert instruction was something that Mr. Smith appears to have discussed with Roderick Williams on or around the 3rd of September 2013. Do you know what I'm referring to?
I saw that. Was it that handwritten note that was put to Mr. Smith?
It was.
I saw that,
Thank you.
and I accept your contention.
Thank you. So it appears that both Mr. Smith and Mr. Williams, at least, were cited on the issue either that Mr. Jenkins had not been properly instructed or at the very least there was a serious question about whether he had.
I'm afraid it does.
As at September 2013. So, where that leaves us appears to be this. Mr. Smith had come to this wide-ranging and serious conclusion about Post Office and Cartwright King failings towards Mr. Jenkins at or around the time of your advice. Yes?
Yep.
He had shared it with a Post Office lawyer.
Yep.
Yes? You two were actively engaged at the time in liaising with Post Office about the apparent revelation of these bugs and the resulting issue with Mr. Jenkins.
Yep.
Yes? You're making the SAMRA call, if I can refer it to it like that, on the 28th of June.
Sorry,
You and Mr. Smith together are making a call to Mr. Jenkins
Yes.
about the case of SAMRA.
Yes.
You're writing an advice in July that deals expressly with the alleged breach of expert duties.
Yes.
You have developed your own concerns about Post Office's knowledge of their disclosure obligations and the way they operated in these prosecutions.
Yes.
And you've said this morning that Mr. Jenkins became the central topic of discussion. Do you remember giving that evidence?
Yes.
And you're in regular discussions with Mr. Smith and Mr. Williams, who it seems were cited on this issue as of September.
I don't link the two together. I accept I was in discussions with Roderick Williams, but not about that. As I've explained, and you can describe this as crude if you wish, but I wasn't interested in why Gareth Jenkins had done or not done what he ought to or ought not have done. I was interested in how it was fixed.
We'll come on to the relevance of the why question.
Yeah.
But you're anticipating my next question. Given all those factors that you accept, is it right that your evidence is that Mr. Smith never discussed with you this conclusion that he had come to as to the lack of expert instruction, and neither did Mr. Williams?
Yes, that is correct.
And you never came to a similar conclusion yourself?
Not knowingly, no.
It wasn't something you had any suspicions about?
I didn't turn my mind to it.
It wasn't a possibility to which you turned your mind at all?
Not at all.
Do you agree that given all of those features that I've just run through, that seems surprising?
No.
Is it in fact the case that you, either by yourself or through discussion with Mr. Smith or Mr. Williams, came to exactly the same conclusion that Mr. Smith had come to around the time of your advice, that Mr. Jenkins had never been informed of his duties and never knew about his duty of expert disclosure?
No. I accept the proposition you put that he wasn't trained and that he didn't know to the extent or what his duties were and were not. I accept that now because I've seen compelling evidence that that's the position. I simply did not turn my mind to it at the time because it was of no interest to me. I was only interested in putting right what had gone wrong. And you have to forgive me for almost cutting you off. I was going to say you have to appreciate, you don't. I wasn't at that point looking back to what had, to why things had gone wrong. It's clear that it's clear to me that Gareth Jenkins had clearly not been trained or instructed in his duties before my involvement in Post Office. I saw no reason to get involved in that because, not least, Post Office were not going to be relying on him as an expert witness in the future. So there was no need to consider the issue, as far as I was concerned, of his training in being an expert witness.
And just to be clear, it's not about training, it's about instruction
by
the lawyers who commissioned his evidence. Is that what you
however
mean?
you want to characterise it, I was not concerned because it was looking back and I wanted to look forward.
And you're saying, although you've come to that realisation now, that's not something you turned your mind to at the time,
no,
and you disagree with my characterisation of that as being surprising?
Yes, I do.
Can I turn then to something you say about expert duties in your statement, please?
Please.
When you looked at Mr. Jenkins' statements for the purposes of your 15th of July advice, did you note that they were all Section 9 statements?
Don't think I did.
Did you note that they did not set out the instructions he had been given or the questions which he was to answer?
No.
Did you note that they didn't set out the written material which had been provided by the prosecutor or the documents, statements or evidence that he had taken into account?
No.
Did you note that they did not contain an expert declaration?
No.
Do you agree that all of those things I've just listed are necessary inclusions for an expert report?
Yes.
Did any of that, therefore, cause you concern about Mr. Jenkins' level of knowledge about his expert duties when you were reviewing those statements?
I think I've already explained my interest was in curing the damage that he had done, not in the reasons as to why the damage had been done. And so, no, I took no notice of any of that.
Well, with respect, the task that you are doing in your advice of 15th of July is before you come to that conclusion, analysing a certain number of the statements that he has provided. Do you
Yes.
agree? And do I understand your evidence to be that at the point that you were continuing that analysis and undertaking that analysis, none of the absence of those necessary inclusions caused you any concern?
No, I was analysing the evidence that he was given, that he was giving in the documents.
And it didn't come to your attention that none of those documents contain the necessary inclusions for expert evidence?
No, because that wasn't my concern. My concern was what had he told the court through the documents.
And it didn't cause you any concern about his level of knowledge about his expert duties?
No, for the same reason. I was interested in what he had told the court through those documents, and that's where my concern was about whether or not he had complied with his duty.
Do you think that was an oversight on your part, not to
No.
turn your mind to that?
No.
A
And I think I've explained why, because I wasn't looking back, I was looking forward to cure the defect that had arisen.
Thank you. And rest assured, I will come on to that question.
I'm sure.
At paragraph 87 of your statement, you say something that you've not reiterated in evidence, and I just want to make sure whether it's something you stand by.
87.
Paragraph 87 of your statement, you indicate that the fact that Mr. Jenkins' statements included the words, "I understand that my role is to assist the court rather than represent the views of my employers or Post Office Limited," informed you that, quite to the contrary of not turning your mind to the absence of knowledge on the part of Mr. Jenkins, that he did understand the duties of an expert witness.
Yes.
Now, is that a conclusion you came to, or isn't it?
No, that's what prompted me to dismiss any thought of looking backwards.
So it's not, in fact, the fact that you didn't turn your mind to it. You turned your mind to it and came to the opposite conclusion to the one that I've suggested.
No, I disagree with that.
Well, first of all, do you agree with the evidence that we have heard from Duncan Atkinson, KC, who's been an expert instructed in this inquiry, that those words included at the end of the statements you looked at, without more, were insufficient to satisfy the requirements of an expert declaration, either at common law or under the criminal procedure rules?
I do.
Thank you. And do you agree that it's not enough to satisfy the prosecutor's obligation as to expert instruction, that a statement simply bears an expert declaration? Because, as Mr. Atkinson, KC, said, it is the duty of a prosecutor to ensure that the expert understands what expert duties entail, for example, the expert duty of disclosure, and complies with them.
I agree with all of that, yes.
Thank you. So, in other words, even if Mr. Jenkins' statements had included a proper expert declaration, which they did not, that expert declaration in itself would be insufficient to inform you that he understood his expert duties.
I agree.
So, having agreed with all of that and bearing those factors in mind, do you agree that if it was your conclusion at the time that Mr. Jenkins knew of his expert duties, on the basis of that phrase alone being included in his statements, that was not a safe conclusion?
I agree with that, but that was not something I was considering, as I've explained why.
Well, I'm sorry, Mr. Clarke. I think what is being put to you is that at paragraph 87 of your statement, you concluded, well, you first of all quote, "I understand that my role, etc." And then you say, on the basis of that, this narrative informed me that Gareth Jenkins understood that his witness statements and oral evidence in court was provided by him as an expert witness. One, that narrative also informed me that he understood the duties of an expert witness. 2. So I'm sorry, but a plain reading of that does suggest to me that you did, in the summer of 2013, take it that because, that you did understand, or you did form the view that Mr. Jenkins understood his duties on the basis of that statement in his witness statements.
Looking back, I think that informed me that I need conduct no further inquiry. And the reason I didn't choose to conduct any further inquiry was because, as I've explained to counsel, I wasn't interested in what had gone before.
Well, all right, you carry on with.
Do you see the difference? I'm grateful to the Chair for distilling the difference between an absence of turning your mind to a question and a positive conclusion, as you seem to indicate in your statement, as to the question of whether there had been adequate expert instruction.
Yeah.
Do you see the difference between those two things?
It's a conflict, I see it.
Thank you. And if it is the fact that you are saying you came to a positive conclusion, do I understand your evidence now to be that that wasn't a safe conclusion in light of the propositions I've put to you from Mr. Atkinson's evidence?
I think that's right, yes.
Thank you very much. Can we turn then to this question of why Mr. Jenkins may have, as you say, failed to comply with his expert duties? I'm not going to take you to your advice. I'm going to summarise it on the basis that I understand you will be familiar with it. At paragraph 37 in your conclusion, you set out that there's been a breach of the expert duties of disclosure, and you quote from that duty in that paragraph. And then at paragraph 38, you effectively say that the reasons for this failure are beyond the scope of your review.
Which, as I think I've explained just a moment ago.
Thank you. If we can just very briefly, please, turn to poll 00172-804, and it's paragraph 22 of that advice at the bottom of page 8. It's the advice that you give on the 1st of July in the case of Samra. Thank you. And it seems from the very last sentence of this advice that as of the 1st of July, you say, in any event, I require a face-to-face conference with Gareth Jenkins upon publication of the second site report.
Yeah, never happened.
I was going to say, why did that face-to-face conference never happen?
I don't know.
Why did you go from requiring, in quite strong terms, a conference with Mr. Jenkins to 2 weeks later advising that the reasons why he might have failed, in your view, to comply with the duty of disclosure was beyond the scope of any of your review?
Because I was looking forward. It's probably why I didn't pursue this. There's a degree of speculation going here because these thought processes were going on 10, 11 years ago. But thinking about the way in which I think about things, I suspect that I abandoned the need for a face-to-face conference with Gareth Jenkins because by the time I wrote the 15th of July advice, I decided that I wanted to look forwards rather than back. That's a bit of speculation, but that's the way my thought processes probably worked.
So rather than an intervening event, you think it was just the development and evolution of your thought process?
Yes.
Is that right?
Yes.
Well, why didn't you consider it vitally important to understand why Mr. Jenkins had, in your view, failed in his expert duty of disclosure?
Because I was concerned with the damage that he'd done to the prosecutions and convicted status of the postmasters and correcting that. Why he had done or not done that which he ought to or ought not to have done was a matter for a different inquiry.
But wasn't it an obvious and important course for you to check the manner in which he'd been instructed?
At the time, I didn't think so.
Not least because there was a clear nexus, wasn't there, between the very breach that you were alleging against him and criticising him for and his knowledge of the expert duty of disclosure.
I think the latter part of that is right, but as I can only repeat, at the time, I thought my priority was different.
And also not least because if he hadn't been given instructions or not given proper instructions about his duties, that might raise issues that had their own impact or effect, to use your words, on past prosecutions, mightn't it?
I'm not convinced it would have changed the landscape. That is, we were faced with a series of prosecutions which ought not to have gone ahead. I don't think it would have changed that. I think it would have changed perhaps the reasoning behind why those prosecutions ought not to have gone ahead.
Can I make some suggestions as to why I say it should have changed the landscape? Firstly, it might have revealed concerns about the conduct or misconduct of individual cases which were under review by Cartwright King at the time.
I'm not convinced I agree with that. We were concerned with whether or not proper disclosure had been made, not whether or not Gareth Jenkins had given, because in lots of the cases he hadn't given evidence, even by written statement.
But if there was a case where a lawyer had failed to properly instruct their expert and you were reviewing that, that failure on the part of that lawyer was an important issue in that case, wasn't it?
No, I wasn't looking at whether or not a lawyer had been improperly or instructed, or whether an expert had been properly instructed or had failed to be instructed at all. I was looking at the proposition that Gareth Jenkins had, for whatever reason, failed to tell us, the lawyers and Post Office and the courts about the existence of bugs when he ought to.
But another reason why it might have changed the landscape is that if there had been that failure, it might have given rise to wider-ranging concerns about the basic competency of the prosecutors within Post Office and Cartwright King and their conduct of these past prosecutions.
I think that's fair.
And it would also, perhaps, have nuanced the extent of the taint that you attribute to Mr. Jenkins, there being, I think you would agree, a significant qualitative difference between a witness who has deliberately withheld information and a witness who has unwittingly and inadvertently failed to disclose something that he didn't know he was supposed to disclose.
I never accused Mr. Jenkins of misconduct. I said that he had not complied with his duty. I was very careful. And I've heard questions in earlier proceedings that go to the question, well, why wasn't Mr. Jenkins reported to the police? There's a very specific answer to that, and it links in with your question. Mr. Jenkins wasn't reported to the police because we didn't know why he had not done that which he ought to have done. And frankly, your questions and your advocacy on behalf of Mr. Jenkins demonstrates precisely why it would have been wrong to report him to the police, because clearly, at this stage, his culpability is much, much lower than it might otherwise have been.
All of those factors that I've suggested might have changed the landscape might have impacted, mightn't they, on the scope of the disclosure obligation that would arise towards convicted defendants?
I think I've already accepted that we ought to have disclosed the issues about Gareth Jenkins in addition to the Second Sight and the Helen Rose reports, yes.
But if you'd asked the why question, further issues might have arisen that you would have also had to disclose, wouldn't they?
I think looking back, that's a proper contention. At the time, we were looking in a different area.
You gave your advice on the 15th of July on your own initiative, you've told us.
Pretty much, yeah.
Post Office hadn't asked you for it?
Not really, no.
You had no terms of reference. You were in complete control of its parameters.
Yep.
Is that right?
Yep.
Is the reason why you turned your mind from this issue in your advice and shut it down because you and Mr. Smith knew full well that a very big part of the explanation as to why Mr. Jenkins had not disclosed these matters is because of failings attributable to Post Office and Cartwright King lawyers?
No, I didn't know that at the time. I've already explained that I had no knowledge of the instructions that had or had not been given to Gareth Jenkins.
And do you agree that if that had become known, it would have been professionally damaging to Cartwright King?
Oh, yes.
And it would have resulted in an obvious conflict for Cartwright King continuing their review process?
Oh, I think that must be right.
Thank you. Do you think that might be the reason why Brian Altman, QC, was not informed of the acknowledged failure on the part of instructing Mr. Jenkins?
Well, that presupposes that I knew about it, and I didn't. Well, Martin Smith clearly knew about it. Perhaps he ought to have told me and Brian Altman, but he didn't.
Okay, thank you. In the final 3 minutes that I have, I'm just going to very quickly deal with the Sam recall, if I may.
Stolen minutes, but 3 minutes it is.
Thank you. On the 28th of June, you've told us you and Mr. Smith made a call to Mr. Jenkins concerning the case of Samra. It was your idea. You asked Mr. Smith to set it up. It was recorded on his phone.
Yep.
Who prepared the transcript?
Martin Smith.
Thank you. Do you know when he did that?
I'm pretty sure I would have said, I want it done straight away.
All right. Mr. Jenkins was given no warning of that call.
No.
He had no prior knowledge of the case.
Forgive me. I don't know whether he was given any warning of the call. We just telephoned him without knowing whether or not he'd been told by, for instance, John L. Singh to expect the call.
Fine. He had no prior knowledge of the case of Samra.
I expect not, I don't know.
Mr. Smith said that at the time you and he were at the very least suspicious of Mr. Jenkins.
I don't agree with that, because the purpose of the call was to find out who told Second Sight about the 2 bugs that Second Sight spoke about.
And to that extent, do you agree that it was to test Mr. Jenkins' credibility?
No, it was to ask him whether or not he knew how Second Sight learned of those bugs.
Mr. Jenkins was not told the call was being recorded.
No.
He was given no chance to check the note for accuracy or understanding.
I don't believe so.
You say to Mr. Jenkins at the beginning of that call, Mr. Singh suggested we get in touch. Yep. You described that as a rhetorical device this morning. Do you mean by that it was something that wasn't true? Was it an attempt to put Mr. Jenkins at his ease in that call?
No, it was simply a rhetorical device so that he could connect with why we were calling. Because, forgive me, if he had been warned, as I would have expected, it would have been by Mr. Singh.
In your advice, I'm not going to take you to it, it's paragraph 30, your advice of the 15th of July, you summarise that call. And in that summary, you say that Dr. Jenkins told us it was he who had informed the Second Sight Committee of the existence of 2 bugs which had affected Horizon. He told us that the extant bug affects Horizon to a limited degree and at specific post office locations only. Bugs have been identified in Horizon which call into question some of the aspects of the way in which it operates. He said that the earlier bug was historic and a patch had been applied to Horizon which had remedied the problem. Can you help us with why in the transcript we don't see any mention that Mr. Jenkins said he personally had told Second Sight about the 2 bugs?
He said we, and I inferred the we to be him.
All right. Can you tell us why we don't see any mention in the transcript where Mr. Jenkins says one of the bugs was extant?
No.
Or where Mr. Jenkins told you that the earlier bug was historic and a patch had been applied which remedied the problem?
No. As I say, Mr. Smith produced the transcript. I don't know why.
So are you saying the transcript was inaccurate or your advice was an inaccurate summary?
Oh, no, my advice is an accurate summary. I don't result from my advice one job.
Right, thank you. Those are my questions.
Time out.
Yeah,
thank you.
Thank you, sir.
That's it, Mr. Blake.
It is, yes. Thank you.
Yeah. Well, Mr. Clarke, I'm very grateful to you for your participation in this inquiry. You have fielded a good many questions, some of which have been hostile, which you have dealt with resolution, if I can put it in that way.
Thank you.
So, for your participation.
Thank you.
(9:45) tomorrow.
9:45, provided my train is on time, Mr. Blake.
Thank you, sir.